the record, would you please state your name?
Marsha Ternus.
Thank you. And for the record, I am Linda Newman. Both Marsha Ternus and I served as members of the Iowa Supreme Court. Do you mind if I call you Marsha?
No.
Good, my friend Marsha. And tell me, what years were you on the court?
1993 through 2010.
Okay. And we're going to talk a lot more, not just about the court, but really about your life as a person, in addition to being a judge. But I wanted to kind of put our relationship a little bit in context. I served with you from 1993 to 2003 when I retired. And I must tell you, when I came into this building today, I was immediately reminded that you really chaired the committee that did the principal planning for this beautiful building. And before we go into a lot of history about you, do you have any fond memories of that experience and designing this courtroom and things like that? And when was that?
Oh, gosh.
That was in 2000. I can tell you it was in 2003 because I only was here for a month.
Oh, really?
I was always in the state capitol. Yeah, the old courtroom. So
yeah. I didn't remember it was that late. But I do, yeah, I guess it was kind of the turn of the century when we were working on it, so that does make sense. But I do have a lot of memories of that, and I wasn't the chair. I think I was just the most vocal person.
And you had the best taste. Honestly, you had the best taste of anyone on the committee,
well,
so we should be grateful for that.
With Becky Colton.
Oh, sure.
She was on it too.
Okay. That was a good pair.
So I will say something a little stereotypical, but yes, the women on the committee were extremely valuable because I think we did have the best design sense. No doubt about it.
Yeah.
Sorry, guys.
Yeah.
But it's true.
Yeah.
And we put a lot of thought and effort into this building, and it's interesting that you said when you walked in, you were reminded of the process to get here, because I had that same impression. I walked in and I'm thinking, you know, I think this has really proven to be quite a nice building. And I'm proud of it, and I'm proud of the impact that I had on it. Mm-hmm.
And it's not just a nice building, it really is a majestic building. Mm-hmm. And as I recall, there was maybe a little controversy afterwards. People say, well, isn't that kind of pretty fancy for the Supreme Court? But maybe we could talk about how the court sort of negotiated with the legislature to get this building in exchange for a restructuring of the court.
Right.
I thought of that on the way over here, and we want to be sure and get that. If I forget it, please remind me.
Yeah, all of that did kind of occur at the same time, and you were on the court, so you remember too, but we were looking at two issues, I think, for the appellate courts. One is that the workload of the Court of Appeals was really too much for the 6-member court. And I think you served on a committee for the appellate rules. Was that for the ABA?
At some point, yes. Yeah. Earlier I had.
But you were very familiar with best practices for appellate courts, and one of them was the recommendation that 7 members of the Supreme Court were probably enough to maximize diversity and, bringing different perspectives to the court. And we had 9. And so somehow the court came to the conclusion that maybe if we went to the legislature and volunteered to have the Supreme Court reduced from 9 to 7 and use those funds to increase the Court of Appeals by an extra panel, to add 3 Court of Appeals judges. That would be a very good thing for both courts. And it just happened we had mandatory retirements coming up, so we could quickly reduce from 9 to 7 without, kicking anybody off the court.
By attrition. By
attrition, right. So we did that, and then at the same time, we were feeling pressure, as I recall, from the legislature wanting our space.
Exactly.
In the Capitol.
Exactly.
And so we began negotiations. I suppose they were primarily Chief Justice McGivern and Bill O'Brien and David Boyd talking to the legislature about what that would mean for the court. And I think we decided we were willing to move, but we needed to have new quarters that would be functional for us for the present and for a long time into the future. And secondly, that would have project the same image or gravitas that the Capitol did, because the judicial branch is a branch of government, co-equal to the executive and legislative branches. And we wanted to be sure that that role was respected in our new building. And the legislature, really, I remember them working pretty well with us in terms of recognizing that's a legitimate concern, and yes, we'll make sure that happens.
As I recall, also with your leadership and the leadership of the people on the planning team, the building itself came in on time and under budget, or at least on budget.
It did, and it's interesting because we were, I think, about $5 million over budget when we had the final architectural plans. And so we brought in an engineering firm to do value engineering, where we were looking at how can we cut $5 million out of the budget and still have the same building when we're done. And it was so painful to let things go, but the people working with us said, honestly, you won't even remember what you cut. And I don't remember what we cut. So they were right.
Oh, that's good. Well,
Yeah.
one of the things, two things that I recall from that time, there was an interview done by the National Center for State Courts people,
right.
Talking about what you need. And one of the questions that came up was, well, don't you need a robing room? And I thought, no, we have an antique coat rack sort of thing where we hang our robes, and that seems to do just fine, Yeah. And then the other thing that I recall is that your committee went around to different state capitals where courts had their sessions in their courtroom, and I'm looking at this beautiful wall here behind you, and it's just sort of stunning in its simplicity. And I recall you came back, there'd been in a lot of these places, there'd been commissioned artworks to go behind the bench, and when it was all done, they looked so terrible that they ended up putting drapes over the commissioned artwork. And you decided, we're not going there.
Right.
We'll just go with a beautiful, is it marble?
I think there were 3 states that had problems with commissioned artwork.
Yeah.
So we decided we weren't going to do it. It's marble or granite.
I
can't
am,
remember.
yeah.
I think maybe one of the most interesting stories about this building is we also considered having the old historic, what was the name of that building?
I think it was the old State Historical
State
Museum or
Historical,
library,
yes.
one or the other.
Really just straight across the campus from us. It was being used for administrative offices at the time, and so we had a study done of what it would cost to make that into a judicial branch
That's
building,
right.
and what it would cost to build something from the ground up. And we found that the cost was the same. One of the advantages to a new building is we could actually accommodate growth for about 20 years, as much as you can predict that, whereas the old historical building, once we got in it, everything would be filled up. And so we decided it was most cost effective to build a new building, and then the legislature could use the old historical building for other purposes. But what I'm getting to is when we walked through the old historical building, we saw these beautiful murals on the walls.
Yeah.
And I'm sure Bill O'Brien on our committee, who knows all this historical stuff, said, well, those used to be on the Supreme Court ceiling in the Capitol. There was a fire in the house, and those paintings got wet, so they took them down, and I think they just rolled them up, and they had a lot of soot on them, and then at some point, the Historical Museum glued them to the walls in that building.
Yeah.
And when the Supreme Court courtroom was remodeled, which I think is when we were both on the court,
Yes.
remember that?
Yeah.
They couldn't put those murals on the ceiling because they couldn't get them off the walls.
Yeah.
Without destroying them.
Right.
And in fact, one of the murals had a vent going through the corner of it. I mean, it was just awful.
Yeah, yeah.
So we saw these murals, and we thought, well, let's just check to see if in the 10 years since that remodeling, or 8 years, we can get these off. Well, there was technology then that allowed us to get the murals off of the walls. And at that time, there was a statute that required a certain percentage of any budget for a building include artwork. So we spent our designated amount of money that needed to be on artwork to restore these murals. And I think they give such a majestic sense to this building. It brings that old feeling of historical importance to it that we would never have had
Right.
if we hadn't seen those murals and thought, well, let's try to get those over here.
That was a brilliant idea, and they are just stunning. And maybe this video could take some pictures of those, because that was a very important part of it. And I recall Becky Colton had kind of an art history or architectural sort of background, and she recognized that there were some really beautiful pieces in the old state capitol. I mean, just like the grills of the radiators and different things, and that had brass features that were significant to the state of Iowa, and oak leaves and birds and stuff, and they were replicated here. So we could spend all day, I guess, on architecture, but I wanted to note just how important that was and how significant this building has been, and it looks today as nice as it did 15 years ago, which is very cool too.
Yeah, I think it looks great.
Yeah, it's cool. Well, before we go back, I want to put this a little in context. I mentioned that we served together for 10 years, but we've had some work together subsequently, and I wanted to mention a story that really kind of, I think it surprised and startled and tickled both of us. We were both at a meeting, an educational program basically, up in Minneapolis on the topic of arbitration. And there were maybe, 40 people there, 40, 50 people in this classroom. And the professor came in and he introduced himself, and he began, as I recall, talking about noting some of the people in the audience that he knew and the relationship that he had with them. And then out of the blue he said, out of the 175-year history of the Iowa Supreme Court, only 2 women have ever served, and they are both here with us today. And Marsha and I kind of looked at each other like, whoa, this guy has really done his homework, and furthermore, we don't think of ourselves as historical figures. And then the fact that in the 175 years there'd only been 2 women, what does that say about the state of Iowa? But I think I will always remember that. Yes, and that's exciting. We'll talk about that too. So, but now instead of buildings and Minneapolis, let's talk about you. Just give us a little background on, well, your date of birth and your birthplace, and what it was like growing up.
All right, well, I was born on May 30, 1951 in Benton County, Iowa. My parents were farmers, and we lived on the farm. I always felt like I just had the best childhood in the world. I felt so loved, and we had a large extended family that we saw all the time. And, we kind of worked hard but had a lot of fun at the same time. So I had a great upbringing. It was really fun. When
you mentioned extended family, so had both of your parents come from Benton County?
Well, my mom did, and my dad's parents, they lived there when he was in high school. That's how he met my mom. They moved, I think they were living in Poweshiek County maybe, or Tama County. I can't remember when I was growing up, but close enough that we went there every Sunday. But I was the oldest of 6 children, and my dad was the oldest of 13, my mom the oldest of 5, and everybody liked each other. There wasn't anything weird going on with family estrangements or anything like you hear about. And so, we just had a lot of fun growing up. My parents were very loving people, and they always made us, I think, feel good about ourselves and feel that, we were supported in whatever we would want to do.
Had they gone to college? Were they college graduates?
Well, no, they weren't. And my father, I think, always wanted to go to college, but he would have been the first one of his family to go to college, and he didn't talk about it a lot, and I didn't sense that he really resented it. But the older I got, now looking back, I can see he really wanted to, that he was a man with such natural curiosity. He always was reading books and National Geographic and wanting to travel, and when we would travel, we'd have to talk to everybody at every gas station, it was just like he couldn't get enough of just learning on his own. And after he died, we were going through his things, and he had a pamphlet from the University of Iowa for new students, and I mean, it just made me cry, because I thought he saved that all these years. I know he wanted to go to college.
Yeah.
And he always made it clear in a very non-pressure way that he expected all of us to do something after high school to prepare ourselves for a career or work. So I grew up just thinking I would go to college, even though, no, my parents had not gone.
Okay.
But I think they were both pretty smart, really. I mean, I even sensed that when I was young.
Sure. Well, obviously, smart and college graduate don't necessarily,
Yes.
you know,
Well, true.
always
Yeah, I mean,
coordinate.
Right.
So you lived on the farm?
We lived on the farm. My parents were really big on education, and we were in a school district that the high school had actually lost its accreditation at one point, and we were right on the line between districts. Our parents wanted to send us to the larger school district and actually petitioned, because back then you couldn't just do it on your own. Your school district had to let you go. And so we petitioned to do that, and our school district wouldn't let us out. And my dad was very upset about that. And so there were 6 of us, and you had to pay tuition at that point.
Wow.
To go to a different school district.
Would this have been in the 1950s or 60s?
This would have been in the 60s, early
Okay.
60s. And so my parents put a pencil to it and decided for what they paid in tuition, they could buy a house in town,
And the town would have been?
Vinton.
Okay.
So when I was a sophomore, they bought a house in town, and we moved to town. So I actually lived in Vinton for my last 3 years. And I think they lived there about a total of 10 years before they actually built a house on a farm that they owned and moved back out to the farm. But it was all because they wanted us to have a good education. And I think it was hard, you know, to not live on the farm and be farming.
That's a big sacrifice in
Yeah.
many ways. But So you went to a local school or rural school for elementary school, and then moved to the larger school in high school?
Elementary school and junior high, and then I went to Vinton when I was a freshman while we still lived on the farm. And, you know, the bus couldn't come into our district, so I had to walk a half a mile to catch the bus. You know, it's just like those stories of I walked through snow.
Now,
I did.
as I recall, you had some pretty notable classmates at the Vinton High School.
Yeah,
Tell us about them.
it's interesting. I had 3 or 4 really close friends, and one of them was Sally Peterson,
Yeah.
who became the lieutenant governor
Yeah.
during the time I was on the court.
And then Catherine Wiedemann, who's a very successful physician over in the Quad Cities, now retired and doing a lot with the Figge Art Museum.
Right. And she just was at my house last weekend.
Okay.
So Kathy was a good friend. And then the other friend was Melissa Lyon, now Melissa Howe. And she ended up getting an MBA and is a chief financial officer for one of the Buffett foundations in Omaha.
Wow. Yeah, it's amazing.
So,
yeah.
Accomplished something.
Well, and I happen to sit on a publicly traded company, holding company board, and the CEO graduated from Vinton High School. He'd been the CEO and president of Transamerica Insurance Company, Pat Baird.
Oh, yeah, I remember the Baird
Yeah, I think
family.
he followed you. And then I'm trying to think of the name of the wonderful judge from Vinton, Van
Zimmer.
Van Zimmer, you know. So that school district and that community developed a lot of really interesting and talented and achieving people.
It was a great place to grow up.
It must have been.
It really was.
It must have been. Well, we could talk a lot probably about high school. And was there any particular sports or activities you were involved in high school? Were you a sports person?
Well, you probably remember they didn't have girls' sports back then.
Yeah, well, that's
I
true.
mean,
Of
we
course.
didn't have a basketball team. I
No.
mean, there were not sports. So, no, I don't know that I don't really like to sweat.
Okay.
Well, did you going out and exerting yourself? Oh, God.
Did you play a musical instrument or anything like that?
Oh, well, actually, that's kind of a funny thing to look back on, because it was the 60s, and the other friend that I haven't mentioned, Mary Carlson, she and I had this little folk singing group, and we played guitars, and we had the long, straight blonde hair like Mary Travers from Peter, Paul, and Mary. In fact, we sang a lot of Peter, Paul, and Mary songs.
Sure.
And we were on Bill Riley's talent, whatever show.
Oh, fun.
Here in Des Moines.
Yeah.
It's funny.
That is great. I didn't realize that we had that in common. I have a couple other things that I was thinking about this that maybe I'll mention, that fun little things.
Did you play the guitar too?
Yes, I played in a little group and sang at the Folklore Center in Denver.
Oh,
At the same time, yeah. But I think it was when then you went on to college, and we're going to talk about that a little bit, but you worked for the JCPenney company, and I worked for JCPenney's in Denver, Colorado.
How about that?
And as long as we're talking about similarities, commonalities, the very first, when you got on the court in 1993, and traditionally there was always a Christmas party for the members of the court and the staff. And I remember you and I wore the same Christmas sweater to the I was thinking about it. Fortunately, it wasn't anything too gaudy. Both of us are, pretty, what would you call it? We didn't wear reserved, So it was sort of a modest Christmas sweater, but to think that we would both have the same Christmas sweater, that just sort of cracks me up when I think about that. So pennies, Christmas sweaters, Mary Travers, lookalikes, Anyway. Well, let's talk a little bit about the move to college. You chose the University of Iowa. Do you remember why?
I think there was something called an Iowa Merit Scholarship at the time, so I had my tuition paid for. I never really considered going anywhere else. I grew up not very far from the University of Iowa, so I was familiar with it. Melissa and Kathy were going to the University of Iowa, so I felt comfortable doing that.
I think it's so interesting as I looked at your resume. Of course, you got your BA in 3 years at the University of Iowa, but your major was home economics. Tell me about that.
Well, it was kind of intimidating going to the University of Iowa. It was so big, and I was just a small town farm girl, and I started out thinking I wanted to major in French, and then that seemed kind of overwhelming to me, and I just didn't know what I wanted to do. And I'd been in 4-H for a lot of years, and back then I sewed all my own clothes, which wasn't that unusual. And so I think I just gravitated to something that was familiar and would make me more comfortable. And so home economics, you had to focus on one of 4 areas, and mine was clothing and textiles, and I enjoyed it. And so that's what I did. I had no clue what I was going to do with it. I didn't want to be a teacher. I had done a student teaching semester in high school. Which I can't remember exactly why they had that, but I did, and I didn't really enjoy it. And so it was just really something that I gravitated to that made me feel more comfortable. I really did find Iowa City intimidating. And of course, back then, there was all of this demonstrating going on, and the armory was burned down, and I was scared to go out of my dorm room half the time. At some points in my college career, I was just
that would have been
timid little person.
That would have been 1969 to 1972, and those were tumultuous times. I was at I was at the University of Colorado, well, from 1966 through 1973, because I did both undergraduate and law school there. And you're right. I'll never forget, in about 1970. I think in the 71 or 72, coming home one night to my apartment in Boulder, Colorado, and there were National Guard snipers on the roofs of the buildings. I can't even imagine what was going on exactly then, but they were wild times.
They were, and I think it was either that first year I was there, maybe the second year, so 70 or 71, probably the same time you're talking about. There was, and I think it was the year the armory was burned down, and there were all these demonstrations going on downtown, and it got so bad that the university said you could, if you wanted to take finals, you could stay and take finals, otherwise everybody could go home. And I had no no question, I was going home.
Yeah.
I was not staying there any longer.
Yeah.
It was scary to me.
I guess that was the situation everywhere, because I had forgotten that, but that was the same thing at the University of Colorado at Boulder. And
so it was quite the time.
it was. Obviously, well, I want to go back a little bit to the home ec only to suggest that I bet you are the only, among a handful, if not the only person who sat on a state Supreme Court or federal court that majored in home ec, but I think that's great. And again, kind of circling back to the building, we're glad that you had that lovely design sense, you know.
Maybe that helped.
Obviously, you did well in college. You were Phi Beta Kappa. I was recently reading a biography of Sonia Sotomayor, and I don't know if you've read it. It's quite wonderful, and she mentioned that given her background, she didn't even know what Phi Beta Kappa was, so that when she was invited, she just threw it away and put it in her wastebasket in her dorm room, and her roommate said, "Sonia, this is serious. This is something you need to pay attention to. This isn't just, you know." And how did you feel when you were invited to Phi Beta Kappa, and what did that mean to you?
You know what? I don't even remember. I don't remember. But I'm sure I didn't know what it was. So either I decided, well, this is a nice honor, so I should do it, regardless of how important or unimportant it is. But isn't that odd? I don't remember being invited, but I remember the ceremony.
Oh, yeah. Cool.
For some reason, I remember the induction ceremony.
Yeah.
So it must have impressed me.
Were there very many, how would you describe the difference between men and women at that ceremony? Do you think there were equal numbers of men and women at the Phi Beta Kappa?
You know, I don't remember that.
Yeah.
I don't recall.
Yeah. Well, so you graduated with a degree in home ec, and so when you graduated, then what came next?
Well, I was trying to figure out a way to use it, and I really liked the textile aspect of it, and I had one of these student jobs for a professor who did research on different finishes on textiles in kind of a chemistry lab, and I really enjoyed that. But you know, all the textile mills were not closed.
Yeah.
They were out on the East Coast, and I was just way too timid to ever even dream of venturing out on my own like that. So my boyfriend was in Des Moines, so of course that's where I came, and applied to Maytag and Meredith, but didn't even get an interview. I don't even remember if there were actual jobs I was applying for, or just sending in my resume. But I had to support myself, so I eventually took a job at a bank here in Des Moines, and I was a teller. And I think that was the first time it dawned on me, geez, sometimes women are treated differently than men. I mean, I don't ever remember thinking that. Although, you know, I must have been aware of it, because I can remember Betty Friedan and Gloria Steinem and reading their books, but I don't think I ever was in a situation where I saw it until I worked for the bank.
Yeah.
And back then, the women were tellers, and the men were the mortgage people who sat at a desk and got to be officers.
Yeah.
And I thought, there is something wrong.
Hey, this is another commonality that I didn't realize, because I did that stint at a bank in the Quad Cities during a time when I was sort of balancing kids and practice and so forth. But it was the same deal, and I was going to be an officer in the bank, but they had asked me to wear the same uniform that all the women did. They all wore navy blue suits. The men didn't have to wear uniforms, and I put my foot down. I said, of course, I was further along than you were. I wasn't a teller. I was an officer in the bank. But to think, in retrospect, that they would make us do that, and I said, I'm sorry, but I'm not going to wear a uniform. As I recall, if there were a special event with the bank, I might wear my navy blue suit. But,
Just for appearance.
Yeah, just for appearances, for photos or something. But yeah, a lot of differences.
But you know, it was one of the good things that happened to me. I really, really disliked that job. But when I looked around and I saw the president and some of the officers, and I thought, oh my God, if that's all the smarter you have to be, you know, to get a good job, I can do that. It gave me so much more confidence and courage.
Yeah.
To do something with myself. I just started thinking, you know, I'm smart.
Yeah.
I can do more than count change and balance my cash drawer at the end of the day and alphabetize signature cards. I mean, I felt like my brain cells were dying by the minute when I was working there for lack of use. But it was a very good experience. And I tell my kids, sometimes the worst experience you have, or one that you feel is, this is such a waste of time, and this is doing, I don't like how I'm spending my time, and it's not going to get me anywhere. You still learn from it. You still get something from it, if nothing more than learning this is not what I want to do. It can be valuable. The bad experiences are just as valuable sometimes as the good ones, if not more valuable.
Sure.
And that was an example for me. So,
yeah,
man, that just lit a fire. I decided, okay, that's it.
And
I'm doing something.
So how long were you employed before you then went on to law school? And tell us about your decision to go to law school.
Well, I actually worked there 2 years, but I decided after a year to go to law school, but then I had to apply and, wait to have the next class start. So I ended up being there for 2 years. And basically what I did is I just started thinking, what can I do? I knew that my home ec degree was not something that was going to get me a job. And so I had decided I had to go back to school. And so I was thinking, well, what can I do that will be intellectually challenging? Because I realized after doing this work as a teller, I had to have something that was intellectually challenging for me. That I didn't have to go back and do more undergraduate work. And so law school was one of those things that popped up. And I worked with a woman whose husband was going to Drake Law School. Actually, I worked with 2 women whose husbands were going to Drake Law School. And one of them mentioned that she was thinking of going to law school. And I just thought, well, why can't I go to law school? But that really brings home to me the importance of role models, because I didn't know any lawyers, I didn't know any judges, and I certainly didn't know of any women judges or women lawyers. And it honestly took another woman saying she was thinking of it, to give me the courage to think, I could try to go to law school and maybe people wouldn't just laugh me into embarrassment when I said that out loud. Mm-hmm. Because really, at that time, I'm sure it's hard for women now to even think that it could be that way, but it was like I was too embarrassed to say out loud that I wanted to go to law school for fear people would say, "What, are you kidding me? There's no way you can do that. Women aren't lawyers."
Yeah.
But I did apply and I got in.
And were there very many women in your class at Drake Law School? Well, and how big the class would have been at that time?
I think the class was about 150 or so, and I want to say maybe 10% of us were women, which at the time was really big.
Yeah, there is kind of a turn.
We had a lot of women in our class, because before that, 5 to, not very many.
Yeah. This would have been 1974, right? Were you there in 1974 to 77? Yeah. Mm-hmm. Yeah.
Different time.
No kidding. Well, tell us a little bit about law school. I will preface my remarks by saying I know you were a very successful law student, but at the time, did you feel like it was hard or easy, or what did you think about the work?
I was so excited about going, and I guess I had a little bit of my dad's love of learning. And I just loved every minute of it. I loved reading the cases. I loved the tests. I was just, a geeky kind of kid, I guess. How about
I
loved it all.
How about speaking in class or being called on in class? You obviously up to this point, you're a very reserved sort of person. How did you feel about being put on the spot in class, or is that a memory that you have?
The memory I have is actually of not being called upon, because we had this one professor, and he was the old style where he just would ask you questions till you wanted to just melt into the seat.
Yeah.
Just get backing you into a corner.
Yeah.
And he would call on different people, and he'd kind of check your name off the list, and he didn't call on me. And so like every day I thought, oh, today's going to be the day. So I was always super prepared for that class, and that guy never called on me the whole semester. And I lived in fear and agony for the whole semester of being called on, and it never happened. So that's what I remember the most.
That's funny. Yeah. Tell us about the things that you were involved in law school besides just taking classes.
I'm not much of a joiner. I'm not sure why.
But you were obviously, somebody noted how good you were at research and writing. And
oh, well, I did do a year as a research assistant for the professor who taught research and writing. And so I would work with students on their, they had to do a memo and I think maybe a brief, and I would help edit them. But you know what, where I really learned how to write was I was in the honors program at the University of Iowa, and you had to write a thesis for it.
Wow.
And I had this professor who, I swear to God, she was like 6'5" and looked like Charles de Gaulle and was really intimidating. And she actually had driven an ambulance in London during the First World War.
Oh my.
And she was a terror. And she was my advisor, and so I had to give her my thesis to review. And I can remember her, I'm sitting there and she's reading sections of it, and she would read something and then she would just shudder because it was so horribly written. And I think I had to read, I think there were like 6 or 7 versions of that. And she was merciless with my writing. And I think that's what, that experience made me a good writer, because she didn't let me get away with anything.
How lucky you were to have encountered her and lived to tell about it.
Yeah, oh yeah, I mean, she was really something else. I don't even remember her name now, but she was, oh my God, she was something. Anyway, so I tried not to do that to my students. I tried to be kind, but still teach them something.
Yeah, I'm gonna have some.
So yeah, that was one thing I did. And then I also was on the law review for my last 2 years.
Yeah.
So I did editing and writing on that too.
Well, and clearly you were respected by your colleagues on the law review because you ended up being the editor-in-chief.
Right.
Was that something that, how does that work exactly in terms of being editor-in-chief, in terms of your getting that position, and what does that entail?
You know, it's interesting because the outgoing board chooses the new officers or board. And so you have an editor-in-chief and a case notes editor and an articles editor and I don't know what all. And so the students who are going to be third year apply for different positions, whatever position they want, and then that board chooses who will fill those positions. I think the advisor, the faculty advisor, has to sign off on it, just so there's some check on the student.
Well,
Student decision making.
Yeah, but it's sort of that role is something that you can carry with you, isn't it? Kind of all through your career. And and having worked with you on the court, you were a person who really paid attention not only to the substance of the decision, which is of paramount importance, but also how the opinion looked, how it would look in published form. You were really great on those rule book, blue book stuff. You know, you were the one.
I loved all that stuff. If there's one thing I've done in my life, career-wise, that I really enjoy, it's the editing. I just love making things, you know, as perfect as possible.
I've got to tell you, occasionally my husband, who's also a lawyer, will ask me to read something that he's written. And I don't know if you've ever had this
same way.
Yeah, and I don't know if you've ever had this experience with Denny, but Henry doesn't handle it too well when I say I would write it this way, or I would say this, or why'd you say that? But I think you and I, we don't have any particular editorial pride. We are used to, from our work on the court and on other places, if somebody makes a suggestion, we go, yeah, well, let me think about that, and we are quick to assume that other people will be grateful for that advice also. Not always the case, you know.
I mean, my attitude was I didn't want to see something wrong in one of my opinions, grammatically or substantively, anything.
Yeah.
After it was already in a hardbound volume. I wanted people to tell me at the conference table, and I'm like you, I thought, well, why wouldn't anybody want that? So I always freely offered my opinion.
Yeah.
And I think everybody took it very good-naturedly.
Oh, absolutely, and certainly on the court. Yeah,
absolutely.
There wasn't any question about that. I think our spouses who haven't had that experience of being criticized and edited by 7 or 8 other people all the time, or 6, are a little less accustomed to that, speaking of what you did in law school and the legal writing that you did, I mentioned to you earlier, I happened to run across a letter that you sent to me in 1993, but when you were applying maybe for the Supreme Court, but in your resume then, there were some legal writings that, my guess is maybe this has fallen off your resume at this point, but this was your legal writing in law school, and the article you wrote was Liability for the Escape of Animals. I thought that had to have drawn on your farm experience.
Yeah, I think I was kind of interested in it because I saw the practical application of it, and I had a case where I got into it, a lawsuit at the firm where I was required to do some research on it, and I thought, the law's kind of screwed up in this area, because of course that kind of case goes back to the territorial court, and so it was really fun just to go back and trace the development of it, and then there were statutes that applied, so yeah, it was fun. It's the only one I ever wrote, I think.
Well, and I need to correct the record here, because obviously you wrote that after law school while you were in practice.
Right.
So that wasn't an article that you had done as a law student. You did write a note in 1976, or was published in 76, so that would have been during the time you were in law school, right?
Was that on, I can't remember what that was.
That was called Act of God as a Defense in Negligence Cases.
Oh, yeah, I forgot about that.
And then the case note that you did also in 1975, which was also published in the Drake Law Review, was concerning Breed versus Jones, and it was a criminal law question. And to be honest, I don't remember what the question is there, but...
I wonder if it involved juvenile law or something about juvenile law. And I say that because, and I don't know why I never put this on any of my resumes, but I had this special project that one of my professors asked me to work on. She was drafting a revision of some aspect of juveniles and involuntary commitments that had a lot of constitutional implications. And so I helped her redraft or revise the current Iowa statute. And I'm not sure what her role was in terms of what she did with the final work product, but I think that's what got me into that case.
Okay. Well, tell us about, did you have other clerkships or work during law school that you recall?
I clerked, my first job I got through another law student who was clerking for an attorney here in Des Moines, and he asked me if I would be interested in doing some work for this attorney too, and it was Ray Rosenberg.
Sure.
Who is long deceased, but he was really a well-known and respected criminal lawyer. And I remembered one experience in particular because it taught me something that I always kept with me. He was asking me to research an issue that he had in a criminal matter. And I researched, and I always thought I was such a great researcher, but I couldn't find anything. And so I go back to him, and we're talking about what I found. And he says, there's something out there, you just haven't found it. And he says, you have to start looking at this issue from different angles. And I can still see him like turning the box.
Oh.
And I said, oh, okay, and I went back, and sure enough, I found some case in Oregon that was right on point. And it really stayed with me because I thought if you dig long enough and if you come at it from different angles, you will find something. And that is true for anybody listening to this. So.
Yeah.
So that was my clerkship experience. And then after I interviewed for a position at the Bradshaw Law Firm, which is where I went after law school, I switched over and started clerking for them, I think my last semester in law school.
Okay. Was there a particular course in law school that you, or a series of courses that you enjoyed more than others, and conversely, ones that you didn't like?
Well, I really liked all the tax courses, I think, because they were, you kind of had to dig in and figure things out, and we all laugh now, 30, 40, 100 years later, that the professor who taught all those courses was quite dreamy. looking.
Yeah.
But no, I really did like the tax courses.
Interesting. And you did well in those classes as well?
Yeah.
Well, you mentioned that you clerked for a year as a student with the Bradshaw law firm, and so going to that law firm, that was your first job, right?
It was. And like everything else, it seems like it just happened accidentally. I was in the law review office, and this friend of mine came in, the one that got me the job with Ray Rosenberg, and he said, are you interviewing with the Bradshaw firm today? And I said, oh, no, I'm going to Kansas City. By then, I was, really worldly. I was going to go across the border to Kansas City. And he said, well, there's a couple slots. He said, you should just interview with them for the practice. And I said, oh, my God, that's a great idea. And so I signed up real quick, and I ran home and put on a skirt because, of course, you would definitely want to interview at that time in a skirt.
Yeah.
Came back and interviewed, and I thought, oh, my God, I love these guys. This sounds really great. And so they invited me for an interview at the firm.
Mm-hmm.
And that's when it dawned on me, and I had a good interview with them from my perspective. I really liked them and the kind of work they were doing. And I said to myself, it's more important that you like the job and the people that you're working with. It doesn't matter if that's in Kansas City or if it's here. And so away with the Kansas City plans.
Wow.
I took the job.
That's great. And how long were you at the Bradshaw firm?
I was there 16 years. Mm-hmm.
Wow, okay.
Yeah.
That's a long time. Tell us a little bit about the nature of cases that you did there. I know there was some sort of evolution there. You started out in one area and moved to another. Tell us a little bit about that.
Well, I was hired to work in the corporate area.
Because you love tax.
States and tax and all that kind of stuff. Yeah, actually true, yes, to do that work. But they had a really nice practice where the new associate would work with every other partner on a case, just so that you could develop personal relationships throughout the firm. And so that meant that I had some small claims cases and some cases where I was helping a senior lawyer maybe write a brief for them, whatever. And I just realized that I didn't like tax in real life at all, and what I really wanted to do was trial work, which was just really going out there for me, I think, at the time, but I liked it, and so that's what I started doing.
So, and I should just, again, to kind of put this, to be sure that whoever is watching this video 100 years from now knows what we're talking about, that the Bradshaw firm is a very well-respected firm in downtown Des Moines. Mm-hmm. How large was the firm, roughly, if you remember when you joined it?
I think around 20 people, and I was the first woman, which was kind of a new and different thing. I mean, it was considered one of the big downtown law firms, and there was a woman lawyer with another of the, I think there were two other women lawyers in the so-called downtown law firms before me. And so I think the firm felt very progressive, because they'd hired me.
And this is 1977, right?
1977.
Yeah.
Mm-hmm.
Tell us then, we'll talk a little bit more about how your practice evolved there, but so what was it like coming into a law firm, not only as a relatively young person, but that everybody else there were men except for the secretaries, I would guess.
It was fine because most of the students in law school were men, so I was just used to working with men, so that really wasn't an issue. I think, I do remember though, it was a period of people kind of deciding how to treat me, and I remember one of the secretaries coming up to me and said, we're going to have a shower next week over the lunch hour for, Beth, who's having a baby, and, you're a woman, so we're thinking we should invite you, but you're a lawyer, so maybe we shouldn't, and, we don't want to make this uncomfortable. Which I thought was just a lovely thing for them to be sensitive to that and ask me did I want to be included in these things or not? And I just felt, although it would have been fun to be included, that I had to mark out my territory as a lawyer. And so I said, I would love to come to those things, but I really feel that I need to not go, just because I want to be sure that I'm treated as a lawyer first and not as a woman. And so I didn't go, and they didn't invite me. But, I had a wonderful relationship with the women in the firm, and, I became friends with a lot of them, so that they accepted that, and they understood that, that I would make that choice. But it was a tough thing to know how to do diplomatically, but it turned out okay.
That's cool. Yeah, that's very cool.
But then when I had a baby, they had a shower for me.
Of course.
I was just fine with that.
Yeah, that is great. Well, let's talk a little bit about your practice there. To be honest, I was dazzled when I looked at this old resume when you were applying for the Supreme Court to see how many cases you had tried to a jury and how many appeals you had argued before the Iowa Supreme Court. I think it was like 79. I have tried 55, you said, this is your words, I have tried 55 state and federal district court cases, and of these 55 cases, 36 were before a jury and 19 were non-jury. And you were sole or chief counsel in 49 of those cases. I mean, this day and age, it seems there are so few cases even tried to a jury. And so for you to have had that experience as a relatively young lawyer and then continue on that in the practice, that is a lot of litigation experience.
Well, of course, I had the luxury of being able to specialize because our firm was large enough, so that's all I did was trial work. But back then, people tried cases, and they don't anymore. And I actually remember one case, a senior partner said, I talked to the insurance company, and this is one they could settle, but they were committed. We had insurance companies who were like long-term clients, as firms do. And they think this would be a good one. There's not much danger that it could really get out of control, that you could try and get some experience. So amazingly, back then, they paid me to try a case that they could have settled, but they knew that it was in their best interest to have an experienced trial lawyer, or
going forward,
associates becoming experienced. So I even that I don't think exists anymore. So at the time, it wasn't hard to have that many trials, and I'm sure a lot of my peers had that many as well. But yeah, now that I look at those figures, I think, wow.
Yeah, that's a lot.
That doesn't happen anymore.
No. And listening to you, I'm sitting here thinking, and you weren't just a lawyer at the Bradshaw firm. You were heavily involved ultimately in a lot of civic activities and professional bar activities. Tell us a little bit about that.
Somewhere along the line, I was strong-armed into running to be the president of the Polk County Bar Association. And that kind of led to a lot of later positions. And so I was elected to be the president of the Polk County Bar Association. And then when you're not the president anymore, then you are the representative, one of the Polk County representatives on the Board of Governors for the Iowa State Bar Association. So I served on the Iowa State Bar Association for a number of years after that. And I think that's also maybe what got me into being a director on the board of directors for Iowa Legal Aid. And I served in that capacity for a few years. And then I don't recall how, but I was on the board of an organization called Community...
Was it counseling?
Counseling, some kind of... It did telephone counseling for people in crisis. And while I was the chair of that board, we were facing some funding issues, which had been going on for a long, long time, and so we ended up merging with the American Red Cross, and I became a member of that board for a few years after that.
Well, I want to ask two questions about that, or inquire two areas. What do you recall learning from those leadership experiences? What, if anything, has stuck with you over the years?
Oh, that's a good question. I can't think of anything that just pops to the top of my mind. They were very valuable experiences, though, because you have to learn to work with a group, and hopefully, when you chair different organizations or boards, you develop some leadership skills. So I'm sure I benefited from them. I'm not recalling anything in particular. I think, though, with legal aid and with the American Red Cross, it had helped develop a sense of social justice in seeing people in crisis and in need that maybe I hadn't been as directly exposed to. You know, when you work for a downtown law firm and you do an insurance defense work,
you're not near the people.
Yeah, you're not near people, and the people that you represent, or their defense is being provided by an insurance company, and it's a different world.
Sure.
So I think it broadened my perspective in general more than anything else.
Well, during the 17-year period of time when you were at the Bradshaw firm, trying all these cases, I noticed you did, I think, 17 appeals to the Iowa Supreme Court that you handled yourself, 15 or 17 or something. You were contributing at the Bar Association level as Board of Governors and these community activities. Somewhere along the way, you got married and started a family.
Yeah, you know, and I know we've probably talked about this, but
how did we do that?
I don't know how I did it. I must have had boundless energy back then that I don't have now.
I can relate to that. But I think you're a very conscientious person, and I am too, and I think somehow we got this all done. But let's when did you meet and marry Denny Drake?
Well, I knew him from law school, but we started dating probably over a year after we got out of law school.
Okay.
And eventually got married, oh God, I don't know.
79, 80.
Oh no, like 1985.
Oh, so you were a twosome for quite a while.
Yeah. Mm-hmm.
Just before you married.
1985, and then had 3 children, and somehow managed, you know, during that period, I don't know if you felt this way, I felt like I did nothing well, you know, because there just wasn't enough time in the day. And I can remember feeling like there was no me.
Mm-hmm.
You know, I couldn't find time to exercise, I had no hobbies. I just did, it was all work and family 24/7. And it's interesting because I loved both of those roles and I enjoyed my life during that time. But you do sacrifice having any separateness when you are in those roles, I think.
Yeah.
At least for me.
Yeah. The articles that were written about you when you were appointed to the Iowa Supreme Court, the interviews suggested that there was a sense that your family was your priority, notwithstanding the great job you were doing as a lawyer and the important work that you were doing there and doing it well, that your family was really your priority.
Yeah. I felt if I was going to have children, they came first.
Yeah.
I suppose then if that was really true, I would have quit my job.
Oh, I don't think so.
But you know, I never felt that I would be a good stay-at-home mother. I mean, I just didn't want to do that.
So in the later years at the Bradshaw firm, how old were those children? Because I know the little one was 6 months old when you came on the Supreme Court in 1993, Brooklyn.
Yeah.
It was
Our
6 months.
Oldest child was born in '88, and so she was 5 when I joined the court, and our son was born in 1990, and so he was 3.
Before we turn to your decision to apply for the Iowa Supreme Court, I did notice in your resume that you were admitted to the Arizona bar in 1984, and I just wondered if you had some plans to depart Iowa. Yeah.
Well, my parents had moved to Arizona.
Oh.
I think maybe in about 1979 they moved to Arizona. And my dad started a career down there selling real estate. And they had been visiting down there because one of my dad's brothers lived there at the time. And my 3 sisters followed them there.
Oh.
And so I visited 2 or 3 times a year. And I really missed them all. And I thought, well, maybe I'll move to Arizona and practice law there. And so, yes, I was considering that.
Oh, and that was before you married Denny.
Right, I wasn't married.
Okay.
And at that time, Arizona wouldn't admit anybody on motion. So I actually had to study and take the bar exam. So I took the bar exam and passed and was admitted. Then I kind of relaxed because then I knew if I wanted to go, I could go. And it kind of took a little bit of the anxiety away. I don't know if that makes sense, but I knew I had that option.
Interesting.
But I never did it, and I never practiced. I've been on inactive status to this day.
Paying those dues every year or whatever. That's great.
It's crazy.
All right. Well, then I want to begin talking, or having you talk now, about the Iowa Supreme Court years, and that was from 1993 to 2010. You were at the Bradshaw firm, and I know you don't just wake up one day and say, oh, I think I'd like to be on the Supreme Court of Iowa. So tell us about that decision to even apply, and what you recall about that process. And maybe we can talk a little bit about what the process was.
Yeah. Well, I had no aspirations of being a judge. Again, it's one of those things that I thought, well, I could never. I mean, I don't even remember thinking that I couldn't do it. I just don't even remember thinking about it. But again, I have all these kind of vivid recollections of things that really kind of woke me up to something. And I had lunch with one of the partners, and we were walking down 6th Avenue back to the office, and he said, have you ever thought about being a judge? You know, you're really good at research and writing. And I thought, geez, no, I hadn't ever thought about that. But, you know, thanks for
reminding me.
Because it did then make me start to look at myself as possibly being a judge. That was a few years before I applied for the court. I just felt that I would not be a very good trial judge because I don't like making snap decisions. I don't like being wrong because I do have to make a snap decision, and I just felt that ruling on
evidentiary things,
admissibility of evidence and the things that come up during trial, and you know, I could get so aggravated with the judge who made the wrong ruling during my trials. I just didn't want to be in that position. And so I just kind of thought to myself, well, if I wanted to be on a court, I probably wanted to be on the Supreme Court because that's where I would do the work that I really like to do. But you know, at that time, lawyers just didn't go on the Supreme Court. They were usually, the appointments to the Supreme Court were usually former Court of Appeals judges or district court judges. So I really didn't have, it wasn't like, oh, I have to do this. It was just something that, yeah, I would really like to do that, but I didn't think I'd really have an opportunity or much of a chance to do it.
So it was Justice Lou Schultz who announced his retirement. And tell us about, so what was it that motivated you to apply for his vacancy? And how much time did you have to sort of think that through, talk to your partners? How did that work?
I didn't talk to my partners very much about that, but
would they have encouraged you if you had?
I think so. I don't think they really wanted me to leave. I kind of had my own little specialty area by then of bad faith and insurance coverage that was going pretty well. But I think the main motivator for me to apply at that point in time was my belief, which was a wrong belief, that somehow my life would be saner on the Supreme Court than it was on the firm. I just had my third child, and I, as all law firms did back then and probably do now, there were certain expectations of how many hours we were going to bill, and I thought, you know, I can't do it anymore.
Yeah.
I just cannot be that productive with 3 kids.
Yeah.
3 kids really
Little.
was sent me over the edge. And so I had approached my partners about a reduction in my hours, and I was willing to take a pay cut twice what my reduction was, which I thought was a pretty sweet deal for them.
Yeah.
And of course, you know, it was a different time back then, but no, that was not acceptable. I had to work my full schedule, just like everybody else in the firm. They were making no concessions. You know, everybody had kids, and you know, if you want to work, that's just how it was going to be. Of course, now they have women working part-time and all kinds of family-friendly
nothing like
situations.
enlightenment, you know.
But, at that time, no, that was not it. And I was really mad about that, because I thought, my gosh, I'm willing to take a 25% pay cut for a 1/8 reduction in my hours, and that's not acceptable. And so I did. I was just a brat. I thought to myself, and I even said this, okay, just pay me 100%, but I'm not going to produce 100% because I'm telling you, I literally can't do it. It was shortly after that this vacancy came up. And I just thought, first of all, I just loved the idea of every day doing research.
Forget those juries, those jurors.
Well, and I tell you, that was part of it, because being a trial lawyer, back in the day where
stressful.
you tried cases all the time, if I was in trial, sometimes they weren't in town.
Yeah.
You work every night to be ready for the next day.
Yeah.
The stress is tremendous. You're working the weekends before and the weekends during. And I just felt that my workload would be more controllable on the Supreme Court, at least when I was, I could control more when I was doing it. And it was the kind of work that I loved to do. I mean, I would actually, when I was at the law firm, I would trade cases with someone who, nobody liked to do appeals really but me, and so I would go in and I would say, if you take this comp case, I will take your appeal. And that's why I had so many appeals, is that I would actually solicit them. So I knew I would love the work on the court, and I was just upset enough about what had just happened with my workload that I thought, why not? Why not try?
That's great.
I mean, I don't know that I ever really expected to get appointed.
Well, let's talk about how that works, and I'll just say, as you well know, in Iowa, essentially you apply for the job, and then you are vetted ultimately by a group on a state judicial nominating commission that's made up of half lawyers and half non-lawyers, certain amount of political and gender balancing there, and the committee of 15 from around the state is chaired by the person who is next in line, but not the chief, on the Supreme Court.
Which was Justice Harris.
Sure, and he was also, when I applied as well. But it is very much you are really vetted by a group of people before then that committee comes up with a nominated slate. So do you recall who was, well, let me ask you first, so did you go around and visit the members of the nominating commission? That was kind of the protocol at that time.
It was, and so I did do that, and I really don't, other than Justice Harris, and I do recall going to the courthouse in Jefferson to visit with him, I don't really have a strong recollection of any of the other interviews, but I know I did do that because I bet for the month before the interview with the commission, my hours were reduced far below 1/8.
It's a lot of territory to cover.
Of time. From one end of the state to the other.
Yeah. But was that an interesting experience, meeting all those people? Yeah. As I recall, they're from Shenandoah, Iowa to Dubuque and further north and east. It's a lot of, So, and then there's it's not public, it is now, but at that time there was an interview with all the people. Do you remember anything about that interview? As I recall, it would be in the conference room at the old Capitol Court conference room?
In the courtroom.
Oh, that's right, I should say in the courtroom.
Yeah, it was in the courtroom.
Of course, yeah.
And I do kind of remember sitting there and answering questions, but I don't remember one question at this point. Do you?
Well, I only remember, of course, I was a trial judge, one of the few, only two trial judges, women trial judges at that time, and so I kind of knew Justice Harris. I didn't go to his office, but he called me, and to be honest, I kind of thought he was suggesting to me, I don't know, he was going to throw some kind of softball about, surely you've never been treated any differently as a woman, sort of thing. Or it was something like that. But anyway, he asked a question like, have you ever been treated any differently? Or do you think the lawyers think any less of you, or something like that? And Bob Waterman Sr., who was on the commission, stood up and said, absolutely not. And I mean, I didn't say anything. It was kind of wild to have like an advocate for you on the nominating. It was the oddest thing. But anyway, that's that's the only thing. Yeah, that's the only thing I remember. But so who were when you got through all of that, and then the commission decides who are the 3 members of the slate of nominees that are going to go to the governor. Do you remember who the other 2 lawyers were?
Well, one was Mark Cady.
Oh, okay.
So he's an easy name to remember. They were both district court judges, and the other was a judge from Marshalltown. Do you guys remember who that was? Would have been?
Peterson?
Yeah, I think it was.
Maybe
Judge
Carl Peterson. Okay.
Yeah, I think that's right.
I think it's interesting that the newspaper articles that were out at that time about your, I don't know if there was so much about your candidacy, it was later on. One of the things that you brought to the court that was different from anybody in a long time, like in 22 years, you were the first person who had gone right from the trial court and had been a litigator to the Supreme Court. Ward Reynoldson was the only one before that, you know, or had been a long time. So, so obviously you had an interview with the governor, and who was the governor at that time?
It was Governor Branstad. The interesting thing about that is it occurred during the floods of 1993.
Oh, yeah.
And so, you know, I'd gone out and bought a new suit for my interview with the governor, and I took it to the cleaners, not very far from, somewhere between where we lived and downtown, to be pressed, so I'd be perfectly groomed for my interview. And of course, we had this
Oh, it was unbelievable.
unbelievable floods and we didn't have any water at our house.
Yeah.
Because we lived in Des Moines, and all the businesses closed. And so I couldn't get my suit out of the cleaners. And I thought, oh, well, he'll cancel my interview. I mean, he's flying around in helicopters and stuff, and really busy. So I called to confirm, you know, that the interview, thinking oh no, we can't do your interview. Oh yes, you know, we're going to do your interview. So I don't even know where I went to
Clean up.
Clean up, found a suit. I mean, I wore suits. Of course, I had a whole
fleet.
wardrobe of suits because that's how we dressed. And I can remember going to the Capitol, and of course, you know, there's no water, there's no air conditioning. It was just crazy. And in comes the governor, and he's got jeans on and some, you know, plaid-looking shirt, and he had just been out surveying all the damage. And I remember all that. I hardly remember much from the interview, but I remember the trauma.
That is so interesting. You know, that's so interesting that the governor and like our chief, which would have been McGivern at that time, were sort of the same way, kind of cut from the same cloth in terms of work must go on, you know, but we'd gotten a call from David Boyd. It was going to be our court week, and David called and said, if you like to drink water, don't come to Des Moines. So basically, court week was done on the phone, I guess.
Really?
The arguments must have been canceled, but we still did our administrative stuff. But the chief felt he needed to get up there from Ottumwa, and of course there were no bathrooms, there was no water. They were lucky they had electricity at the state capitol, and it was hotter than blazes.
Yes,
you know.
I remember it being so hot.
Wow. Well, of course, so then the big decision was made, and you were announced as the next person to sit on the Iowa Supreme Court. What did you think about that?
I was just overwhelmed and overjoyed. I was so excited. It was such an honor, and I just couldn't wait to do the work. I just couldn't wait to get those first sets of briefs and to write opinions. I loved it. I loved it. I really felt like I was born to do that work.
Yeah.
It was like everything about me just fit like a glove.
You know, that's so interesting you say that, because so often trial judges, and I think I felt the same way, I was more of a decisive, liked to run the courtroom as a trial judge, enjoyed the people and the commotion and the chaos on Monday morning. And so then being in an appellate situation, it is quite different. You know,
hugely different.
Yeah, and I love that work too, and I love the writing, and I love the working with colleagues and stuff. But it is a very different job. But you were really cut out for it. Tell me how your family and friends and law partners reacted.
Everybody was very supportive and very excited.
It's a fun time, isn't it? I was thinking with the newest justice being sworn in this week, I kind of wanted to tell her it's great fun to be, you know, a celebrity for a day, and then you have to get down to the work.
Yeah, and back then it was more more easily visualized because you would get it in boxes. Now it's all electronic, so you don't know how overwhelmed you really are.
Yeah.
You can't see it.
Oh, yeah. The first time when they sent the boxes over to, I think, the Scott County Courthouse for my first set of cases, and you may remember that you actually start working before you're sworn in. You are formally sworn in, but then the celebration comes later.
Because you actually sign an oath. Yeah. That's the formal. That's the real thing. The ceremony's all phony.
Yeah, without fear, favor, or hope of reward.
Yeah.
Administer justice equal to the rich and the poor.
Fortunately, there is a paper oath, because when I was sworn in, somehow Governor Branstad came over and he didn't have the oath with him.
I remember that.
So McGivern's flipping through the code trying to find it, and he finds the wrong one.
Yes, I remember that.
I remember when I'm taking the oath, I thought, boy, this doesn't sound very lofty.
No.
Doesn't sound like much. It was like the oath for notaries or something.
I remember
really
that.
Crazy.
I remember that too, because the one that judges actually take,
it
is that, and without fear, favor, or hope of reward will you administer justice equally to the rich and the poor, as I recall.
Yeah, I can't remember exactly how it goes.
But it is something. Yeah. Well, I think we all kind of went, on the bench like, wait, that's the wrong oath.
That can't be right.
you agreed to uphold the Constitution.
Yeah, I'd already agreed to the right stuff.
What I remember is Brooklyn, the baby, 6 months old, being, juggled around from person to person and so forth. And as a mother myself, I remember at the court, I thought, whoa, at least my girls were 5 and 9, having a baby, that was going to be interesting
I remember
time.
It was funny because I'd just been sworn in, and then the protocol or practice was that the spouse would help the new justice on with their robe, right?
Oh, yeah, yep.
Anyway, so somebody gave Denny my robe, but he was holding Brooklyn.
Yeah.
And I don't know why. Well, I think my mom was sitting there, and I think Whitney was sitting on her lap, and Rob was asleep with his blanket on the floor.
Yeah.
And so Denny, the governor had stepped back, so Denny just handed Brooklyn to the governor. And there was he had a little blanket, and I can remember seeing him drape the blanket over the governor's shoulder, just in case, Brooklyn spit up or something. And then he took the robe and put it on it. And, the governor, he didn't bother him.
Yeah. That's so great. Those are great memories, aren't they?
Yeah.
I hope there were cameras there recording all of that.
I think I have some snapshots of it. And when I was taking the oath, the Des Moines Register reporter had an angle where right between the governor's and my head on the floor behind me was Rob.
Yeah.
Snuggled up, taking a nap on the floor. It was so sweet.
Yeah. Those are great. Yeah, my youngest, Lindsay, was just laying on the chair, just like this, bored to death, so. Well, so then tell us, so you started on the court, you thought the workload was maybe going to be easier or something, but tell us a little bit about the workload, and of course, judges like ourselves never talk about cases that we've written because the opinions speak for themselves. But I'd like to talk just a little bit, or have you talk a little bit, about the process and how you approached the opinions and the cases that you were assigned and the decision making. Tell us a little bit about that.
Well, the workload is extreme.
Yeah, it's
People
surprising.
think, they only write a few opinions a year. How hard can it be? But it was very burdensome. There's so much reading to do. And to write a good opinion takes a long time.
Yeah.
I wrote all my own opinions. I was never going to let anybody else write them. I think my first year, I let my clerk, we only had one clerk, do a draft of an opinion. And I thought, oh my God, this is more work than, the clerks wanted to do drafts of opinions, was my, impression. So I let my clerk do one, and she was a wonderful law clerk, don't get me wrong, but her voice wasn't my voice.
Yeah.
And I ended up, then I had to try to use as much of hers as I could because I didn't want her to feel bad. And so that was the first and last time that ever happened.
Yeah.
And so I wrote my own decisions. I always checked research because of Ray Rosenberg.
Yeah.
I always thought there's always something out there, and I want to make sure they found it. And that offended my clerks too. But my name's going on it, not theirs.
Exactly. I'm sitting here picturing how it used to look downstairs. You and I had adjoining chambers. I would only be there a week a month because that's kind of how we did at that time.
And then Lavarado was next to me.
Yeah. So it was the three of us in the garden.
4, because Jim Carter was right across the hall from you.
Oh, that's right.
How could you forget him talking on the phone?
That's right.
It reverberated through.
That's great.
All the offices.
We're in the garden level. That's so wonderful. But what I recall, I don't think we were doing much legal. Maybe by the time you came in '93, there was more electronic research. Because what I remember is the library carts that had all the books lined up.
Well, in our office, we each had a set of the Northwest Reporters.
Yeah.
But I had begun doing electronic research at the firm. And so, yes, I was doing electronic research. And I had also at the firm begun drafting my own briefs and motions and stuff on a computer, which, by the way, I really had to fight to get at the firm because they didn't want lawyers keyboarding everything because that was women's work. It's true.
Well,
anyway, so I did bring that to the court, and I can remember Lou coming in and wanting to see what I was doing, and he eventually then got a computer because he realized it was so much more efficient to do your own drafts.
Yeah, and I think, but you clearly were much more advanced and technologically savvy than any of us were, and none of us had computers at that time. And I sort of had the same experience that you did.
Have electronic research in college, or in law school? I didn't think you were that far ahead of me.
I was that far ahead of you.
Yeah.
Yes,
well,
we didn't have any.
It came in right then.
Exactly.
I remember when I was a student, I remember it starting, so yeah, maybe that was after you were in law school.
So I was never very good at it. And I can remember going to a planning meeting for an ABA committee that I was on nationally, and talking to members of the Supreme Court, and I mentioned that I was still writing my opinions out in longhand with a pencil, and they all went, and it became the joke of the group. But it was that my sharing that experience with some legislators that at least got us some computer stuff, in the court. But so tell me about your clerks. I only remember 2 clerks that you ever had because you had one for a permanent clerk for a very long time who was wonderful, and one clerk from the University of Chicago, I recall, a young man who maybe wasn't quite so wonderful.
Edit that out.
Yeah.
Well, Linda Hines was my first law
Oh, that's
clerk,
right.
and
Okay.
she was wonderful because she had clerked for Justice Schultz.
That's right.
And I was sworn, I think I signed my written oath maybe sometime in August, but the first court week was in September. And of course, the hiring cycle was totally off for getting a law clerk. And she agreed to stay another year, which is wonderful because, she kind of knew how the court worked, and I didn't have to hire anybody, and she was a lovely person.
Yeah.
So she was my first clerk. But my long-term clerk was Jocelyn Andreessen, and McGivern wasn't, I don't know if you remember this, but he wasn't too happy that I was going to keep a law clerk year after year because he felt, and I get this, that it was kind of our responsibility to train and mentor young lawyers, and we did that by having a new law clerk each year. And I remember saying to him, maybe you have the time for that, but I don't. I have to be as efficient as possible. I have laundry to do at home. And so I need a law clerk who knows what they're doing, whose research I can rely on. And so when I hired Jocelyn, and she was an older law clerk, she'd been a nurse for a long time and then went back to law school, so she had a level of maturity. And she had children she was raising, and the law clerk schedule and role fit in with her life just perfectly. And so I said, you can stay as long as you want. And McGivern wasn't really upset with me, but he took a different philosophy, and most people on the court did. But for me, it was just I don't want to be as dramatic as a matter of survival, but it was important that I not have to, because just about the time that you got a new clerk and they started kind of knowing what to do, they were gone. And then you had to spend all that time interviewing. I didn't have time for it. So I didn't do it. I think I had 5 clerks maybe. Over the time, and I think everybody got that. That was an individual decision that judges could make, and there is no doubt that it was a lot harder to
train someone. They all came in with such enthusiasm, and by the about the time they're ready to go off to their next job, they've figured out what to do. But
and you did, in particular, a great job, I don't know if this came out in your interview, of hiring clerks who were diverse. I don't know if that was intentional or not, but you really had, if you lined up all your clerks, I think they were very diverse, and they came from different schools and different backgrounds, different race, men, women.
I tried to.
Yeah, you did.
I tried to. Well, I think Justice Clay LeGrand had given me the idea along the way that he would alternate male and female every year, and I tried to do that, and I really did try to look for more racially diverse clerks, but it was really, that was a difficult task on a variety of reasons, and we don't need to go through that here, but I tried to, and that was, and I really enjoyed having that. Different people every year, and by and large, they were just wonderful. Well, so we talked a little bit about how you wrote your own opinions and spent a lot of time researching and so forth. What other kind of assignments did you have and things that you did while you were on the court besides the adjudicative side? I think of you as taking a fair amount of responsibility on in the committee work that we did.
Well, I was on the Bar Conduct Committee with, I think Justice Harris chaired that while I was on that committee. And we would review applications for admission on motion and things that came up from the Ethics Committee or Grievance Board. And everybody on the court had a different committee assignment, and that happened to be mine. You and I were really, well, you in particular on the Long Range Planning Commission, you chaired it.
It was big.
And I was responsible for some aspect of that. I can't remember now.
It wasn't just one small aspect. I mean, I think you and I took a pretty big lead on that, but it was a very diverse committee.
Yes, that was a wonderful experience for me.
Yeah.
It really was. I felt like I got to know a lot of lawyers across the state, and we were really digging into how to make the court system better. And a lot of the things that we identified as issues and possible solutions came to pass. I know during your time on the court, we actually got that report out, and we used it, and we continued to use it.
Yeah, that was the Commission on Planning for the 21st Century. And we got a pretty broad steering committee, and then broadened out. It was a long-term project. And what was wonderful, I thought about that, was that we spent a lot of time deciding who should be on this big commission. And someone later told me, I asked them, well, why did you agree to serve or something? And it was, Justice Ternus called me and asked me, and I didn't know how to say no, or the same thing with me, So we just got on the phone and called people and found out that direct contact, and we sort of told them, this is going to be a big project, and you're going to agree, commit to it, and we're going to have a lot of meetings. But I do think overall people felt good about it, and I was always glad to see that the court continued to use it, because that was the whole idea, is to make the court more efficient and so forth.
Yeah, but, I think it was a very, very valuable thing. A lot of times you have commissions or task forces and their report kind of sits, but that was not one of them. That was a living, active document.
Well, we had a cool guy who was guiding us. We were able to get a little money to hire that nice guy from Oregon. Who was a planner there.
And then we had a wonderful
and Kate Corcoran,
executive director.
Yeah, Kate, one of my former clerks.
Great writer. She wrote a great report.
Yeah. So it was that was a big experience. When I look back and look at the pile of stuff I've got, there was a lot of. I went through a lot of papers recently, and, and a lot of that went out. But let's talk a little bit though about the opinion writing and the decisional work of the court. And sort of the give and take that goes on. What are your recollections of Court Week and Decision Conference, and just your experience with that, and did that evolve over time, get easier or harder, or what are your recollections there?
I don't think it got easier or harder during the 17 years I was on the court. And as personalities changed and court members turned over, it was always different depending upon who was sitting at the table. But I will say this about the whole time: there was it was such an honor to be part of the court, regardless of who constituted the court at any particular time. There was such integrity at the table. There was such scholarship, such a desire to have principled development of the law, such efforts to be neutral and to get rid of, to test our decisions for bias or stereotyping, or, I just think that there was such an effort to have quality opinions. It was wonderful. It was really wonderful.
One of the things I remember particularly about your contribution was coming from the trial practice and the appellate practice and having to write briefs. You were troubled by sometimes the inability to reconcile two different lines of authority that might be out there, and you would regularly remind us. I mean, if there was a case that, but wait a second, how are we going to reconcile it with this case? And that was obviously it's an important thing. But I think I have the sense that you were particularly attuned to that because of the work that you've done as an appellate lawyer. Is that true?
Yeah. Yes, it's interesting because when I was interviewing for the job with the governor, I distinguished myself from the other two candidates who were both trial court judges by saying there hasn't been a person on the court who has recently practiced law. I mean, there's nobody on the court now who brings a current understanding of what it's like to practice law. And you need that perspective on the court. And I believed that. But I will say I was surprised at how true that really was once I got on the court. And it was because of things like that I would say, wait a minute, we have got to rephrase this. Because if I was sitting out there as a lawyer, I would think, what the heck are they trying to say here? Or I do remember the two lines of authority and always saying, well, wait a minute, what about all these cases we're not following? Are we overruling them, or are they distinguishable? We have to do something. And I can remember, and I'm going to name the name because he was so clever, and he didn't really mean this, but it was Jim Carter. And
I thought it had to be Jim Carter.
He had written the decision, and he hadn't distinguished the line of cases he wasn't following. And I said, well, Jim, how are lawyers supposed to figure this out? Or is this case what they should follow, or how about all these other cases? And I said, you have to either distinguish them or overrule them. And he says, well, maybe we might want to use that one someday. And that's why I wasn't going to do it. Of course he did. Yeah. He did take care of it, but I thought, oh my gosh, that was so funny. He was so funny. I'll never forget one day when, same sort of thing with Jim Carter, but Dave Harris was suggesting that something in the opinion, he said, Clay LeGrand would not have liked this. And Jim said, Clay's not here, Dave. So we don't care. So we don't care. But a little bit of court levity. But I can remember him saying once, he was trying to get some point across to us, and we were all being dense apparently. And he was, how he could kind of get, frustrated, not angry, but really frustrated. And I remember him holding it and said, it's like a stick has two ends. It can't be any other way. I really thought you had this tremendous background and academic and intellectual background. And Jim was really an intellectual sort of guy,
he was so
too.
smart.
And so I always found, when we circulate our opinions, and if I hadn't heard from you or Jim, or you or Jim Carter had said, I want to talk about this, or, you didn't vote on it, I thought, I better sharpen up my analysis on here, because you were the only two that I shouldn't say the only two, but you were two. I really paid attention to the two of you. Now, was there anybody like that you can think of on the court that you were more mindful of their input or potential disagreement with you or anything?
Well, I mean, I was concerned if anybody did, honestly. I don't remember feeling more so with one person over another. I'm sure if I could remember well, there were people who would be more inclined to do that, because I think, at least when I first came on the court, I sensed and experienced that there were people on the court who felt that once the case had been assigned to them and they had written the decision, that there was a lot of latitude that should be given to them. You're frowning like you didn't have that sense, but I did, and that if they wanted to say it that way, they had the opportunity or liberty to say it that way. And of course, I probably came off being, especially in those first few years, not being very collegial, because I figured, well, if I didn't like something or agree with it, my duty was to speak up. So I'm always, quote, criticizing somebody's opinion, and they would hardly ever do that back to me. And I just think it was because they were much more comfortable, as long as they agreed generally with how you'd stated it and what the result was, that you could say it however you wanted, and I was much more nitpicky about it. I remember that more than anything.
That's really interesting.
Isn't that funny?
And I recall that as well, and I think it's really important in terms of how one shapes opinions. And I was certainly never reluctant either just to call people or mention things. Dave Harris was always the one who would call me and say, Linda, do you really want to say this, or I can't even think of a good example, but I tried to be sensitive to those things, and in retrospect, I was always grateful that I might have taken something out.
Oh yeah, me too. I really wanted people to comment on my opinions, because I wanted them to be as good as they could be.
Yeah. This reminds me too, when you came on the court, there were still 9.
Yes.
And so because of the caseload, we didn't want it, and the Court of Appeals was undersized, we kept a bazillion cases, and we had to sit in 2 panels.
Right. I can remember screening cases, and we would keep a case that was clearly under our rules, a case for the Court of Appeals. But because it came with like 5 boxes, we would think, well, they don't have time to go through all this. So we would keep those cases.
Yeah. There was a lot. And as you said, everyone was very conscientious about the work, but there was a lot of work to be done. But then when you come to opinion conference, 5 of the members of the court had heard the arguments, 4 had not. If there was any dissent among those 5, then everybody stepped up and familiarized themselves. But otherwise, I suppose a fair number of things kind of, well, it's good enough that those 5 and they're comfortable about it. We had plenty of work to do without creating more work.
Unless it was something that you already knew about. You really didn't question the other panel. Which is odd. It was, and we didn't talk about this earlier when we talked about going from 9 to 7, but that was really one of the driving forces from going to 9 to 7 and increasing the Court of Appeals, was so that the Supreme Court didn't sit in panels, because you had pointed out that is totally against best practices to do that. And it was not conducive to a good principle development of the law.
I think the records would show in some of those years we would do between 400 and 500 opinions a year. Imagine that.
Wow.
For a court of last resort.
Yeah.
What I was going to say, I wanted to mention too, though, and you kind of touched on it a bit. You had such background in insurance defense. I mean, in interpreting insurance policies, and that I think that's where, in particular, your background said, let's get the law straight here.
Yeah. And the cases were all assigned randomly, so if I happened to get one, it would just be by accident. Which I thought was good. We wanted everybody to contribute equally on any issue that came before the court, and not develop little areas of expertise.
Right. Yeah. And that made the work interesting. Too. It really was. In addition to your work on the court, you were also involved on the National Conference of Bar Examiners, as I recall.
Yes, I was on there. It was when they were starting to develop the multi-state performance test. And so I was on the committee, not to develop the test itself, but just decide, how it would be implemented and how it would be fit in with the other test. It was more of kind of an administrative implementation kind of committee, which was a lot of fun though. And then I did become, for which I will live in infamy in Iowa, very assertive about, we have got to change the Iowa bar exam. Did you forget about that?
Okay, yeah. There were a couple different times.
Weren't you on the court then? Oh, yes, you
I
were,
must have
Linda.
been, sure.
Yeah, you were.
Sure.
Yeah.
Yeah. And we knew it.
And Dick
wasn't up to
remembers
standard.
that.
Yeah, sure.
It was very controversial, but
Yeah.
had to be done.
Well, it was controversial too when we decided to work this deal with the legislature and get more Court of Appeals judges and the court, because we hadn't consulted with the Bar Association about
I know.
that.
Anything that was, if I learned one thing at all from being on the court, is that any change is going to be resisted. It doesn't matter how
Yeah.
obvious it is.
Yeah,
It doesn't matter what the benefits are.
yeah.
People don't like change, which to me, and I don't have any anecdote to cite in my background, but for some reason to me, change has always been exciting, because I don't look at it as a change, I always look at it as advancement, improvement, something new. Isn't this wonderful? And so I was just shocked to see the just immediate resistance to anything that was a change. And sometimes even at the expense of, I don't even want to hear why you want to change it. It's just wrong. It's always been this way. Yeah. If it ain't broke, don't fix it. Oh my God, I got sick of hearing that. So,
well, we just plowed ahead anyway on that, because it was
did.
so important to the court, and the timing was right with the legislature, and we just, they got over it.
Yeah, they did. But the bar exam, I think, had, people griped about that for
I suppose.
probably a generation.
Yeah,
They probably still are griping, are they, Dick? No, they're not griping anymore. Good.
that's good. Well, I retired from the court in 2003, and so then you were the only woman left on the court, and then the chief retired, and anyway, you became the Chief Justice of the Iowa Supreme Court, and I'd like to talk about that period of time. And do you remember what year that would have been?
I do. It was in 2006.
Okay.
The summer of 2006.
And so from 2006 to 2010, basically, you were the chief. And you were, tell us how a person gets chosen to be the chief.
The court itself chooses the new chief. So I was selected by my peers.
That's a nice feeling, isn't it?
It is, yeah.
I think that
It really is.
Yeah, that's pretty cool, because many states, the governor or somebody else kind of anoints
Or seniority
somebody.
or something.
Yeah, or seniority, yeah. And so how did that change, that elevation to the chief? Change your work on the court and relationships with colleagues and the public?
Well, it puts you more in the public eye, which I really hated. And I really honestly didn't enjoy the administrative work at all, because it took me away from the work that I really like to do, because the chief has to take a reduced opinion writing load. I mean, there's just no way to do all the administrative work and continue to write the same amount of opinions. So I really missed that, and I must have been halfway insane to even do it, because it's a thankless job, and like I said, not that much fun at all compared to the court's real, adjudicative work.
Yeah.
But at the time, I really felt that there were things I could do in a leadership role that were important, and so, I did it.
I was thinking that you'd had to present to the joint House and Senate and give a State of the Judiciary address every year. How did that feel, and how did that go?
Well, I mean, it's in a way it's really embarrassing, because they march you in with all these legislators and everybody claps and stands, and it's like, oh geez. I didn't mind giving the State of the Judiciary. I really didn't mind it. Somewhere along the line, I guess, public speaking didn't bother me too much. I mean, I was nervous, but I knew what I wanted to say, and I felt that we had important things to say to the legislature, and I felt it was really a good opportunity to educate the legislature, and so I welcomed the State of the Judiciary. I didn't mind doing it. And, Becky Colton, and I can't remember what her title was, but she was basically the right-hand person for the chief.
Yeah.
And she did all the first drafts of my like opinions. I was happy to hand it over to her. She was great at speech writing. I think that the main switch she had to make from me to me from McGivern and Lavorado is that I told her I will not tell any jokes. You know,
Yeah.
they'd always have some little
Way to
cute
open
little
up.
thing. Yeah, and I said, I'm not a joke teller.
Yeah.
I can't do that.
Yeah.
But she wrote great speeches, and so that was took a big burden off me. I didn't mind giving. I enjoyed giving them.
Cool.
So
Yeah, and I suppose as part of that, then you also became a member of the Chief
National
Justice,
Conference
yeah.
of Chief
Yeah,
Justices.
tell us a little bit about that.
Or the Conference of Chief Justices. And that was fabulous because you were with a group of people who were dealing with the same issues, you know, who held the same position in their states, and you could learn so much from them and get such good ideas from them. I loved those conferences were very valuable to me because of the sharing. And I'm sure you had the same thing on your ABA committee.
Yeah, you
work.
meet amazing people from around the
Uh-huh.
country,
Yeah.
and it was a neat opportunity to do that not
So,
everybody has
yeah,
anymore.
I really enjoyed that.
That's cool. I've heard recently that you don't want your legacy to be that you were the Chief Justice when the marriage equality case came before the Iowa Supreme Court. But I do want to talk about it a little bit, from largely from a procedural standpoint. Varnum versus, I've heard you call it Varnum versus Breen. Breen, it's not Brian.
Right.
It's Varnum
versus Breen.
Breen. I want to talk about that and its aftermath, essentially. So how was it that the court decided to change its usual process of hearing arguments and stuff in limited times and so forth like that? How did the court become aware that this is a big deal case?
Well, you know, there was so much publicity and public opinion voiced when it was in the district court that we certainly knew that it was going to be a case of great public interest when it came to us. We basically followed the same procedure for that case that we followed for any case, with some exceptions. One, when it came to time to assign the case, the chief assigns cases randomly in the Supreme Court. And because this case was going to be so controversial, and because probably nobody wanted to be the one to have to write it, the random assignment was made at a court conference instead of me just working with my secretary to make it. And so we actually drew numbers out of a hat, or out of a little silk bag that my secretary had, and then that determined the order within which we would draw cases for the next assignment. And because Varnum versus Breen came with, it was a summary judgment case, but we had a banker's box just of a brief amicus briefs, yeah. We decided, due to the importance of the case, everybody would just have one case assigned for that month. So we reduced our normal case workload by quite a bit to accommodate the Varnum case. So we went around the table and we drew numbers, and then I put the 7 cases written on slips of paper in the bag, and then we went around and drew them out. But we were so ignorant that when Katie drew out Varnum, I remember he drew it out and he said Varnum versus Breen, and I tried never to read the paper because I didn't want to be influenced by that. And somebody had to say, oh, well, that's the same-sex marriage case. You know, it's like, that's how oblivious we kind of were at the time. So that was kind of a little modification of the random assignment, just having it be more, quote, public within the court itself. Then we extended the argument time. I don't remember by how much, but by a substantial amount. Normally it's 10-10-5.
Yeah.
And then the final thing we did is we did a live broadcast. We worked with Iowa Public Television so that it could be broadcast live, so anybody who wanted to watch it could watch it. I don't know if that was streaming or if they showed it on TV. I don't remember.
Do you? I don't quite, but I think I was watching on my computer.
But after that, in terms of the conferencing the case and issuing the opinion and all that, just was normal.
I should say for the record that the final decision, of course, was unanimous. There were no dissents or special concurrences in the opinion. I still remember the day that it was announced, and I happened to be in an airport, and I saw it like on CNN or whatever it was on the TV. And the next thing, my little cell phone starts going, people so excited that I knew about it, you know, and it was kind of thrilling. But there were really two sides to that reaction, I am sure. First of all, I want to ask you that in retrospect, would you or the court handled the case any differently than you did?
No, absolutely
Yeah,
not.
I kinda
No.
figured that.
Mm-mm. I
Yeah.
mean, it was just another case.
Yeah,
For the court, it really was just another case,
yeah,
and we handled it that way.
yeah. How did the decision, the public reaction, pro and con, impact you personally and your family? Because there was just a lot of stuff afterwards about it.
Well, afterwards, I really didn't pay much attention to all the hoopla that came out in terms of people praising it or criticizing the decision. I mean, I was aware of it, and at that point, having already decided the case, I felt more at liberty to read newspapers and listen to accounts on TV, but all of that didn't make any difference. I mean, we had already decided the case, and I just felt I didn't need the stress of listening to people saying it was a good decision or the best decision that was ever written. It was what it was. It was finished at that point.
Yeah. I heard that Mark Cady, who was the author of the opinion, he spoke to a forum at a church here in Des Moines, and he told them that after the opinion, and maybe I'm confusing this because it might get closer like to the election, although he wasn't on the ballot, so, but because of antagonism against the decision, that he actually wore a bulletproof vest for a while. Did you remember that?
Gosh, no. I don't remember that.
Evidently there
wonder
was-
if he didn't share that. I don't remember.
I think there was a lot of negativity that came towards him and wacky people. you
There
know?
was, and I do remember that there was some incident, and I don't remember whether it was a phone call or a letter or something, where we were warned, the members of the court were warned of some kind of threat. And I remember telling my children not to answer the door at our house and to stay away from doors and windows if anybody came up our driveway.
Wow.
So, you pay attention to that.
Yeah, no kidding. Yeah.
Mm-hmm. And I think that was scary for my kids. Whitney was away at college by then, or I guess she was doing a Vista year. But the other two were home, and yeah, that was scary.
Yeah.
I'd forgotten about that till you mentioned
Yeah,
it.
it would have been. Well, it made quite a splash nationally.
Mm-hmm.
And, people were really sort of interested in that, and the press can really pick up stuff like that. Well, so you kind of went on with the rest of your work. The next month you probably had your regular assignments and went on.
Uh-huh.
And then the election came up,
Mm-hmm.
and you and Mike Streit and Dave Baker were on the ballot. And as we all know now, and it almost, here I'm going to get emotional just thinking about it.
Oh, don't.
Well,
It was okay.
yeah, but it just, things just really went sideways. But tell us how the three of you approached the election and the onslaught of outside money and the move to unseat the three of you in a
Well-
retention election that ordinarily would not have been controversial,
Yeah.
but for one case.
Well, the Varnum decision came out in April of 2009, and by 10 months later, and the election was November of 2010, but by early 2009, I think we pretty much knew that the national organizations that opposed same-sex marriage were going to try to unseat us. We weren't sure that was going to happen, and there wasn't anything really actively occurring on the ground, but we were aware that that could happen. And we were troubled by, what the three of us should do. I do remember going to a bar association meeting, Board of Governors meeting in March. The chief always went and gave a report, and I can remember somebody saying, well, lawyers don't want you to campaign, and we'll have your back, we'll defend the court and its decision and the three of you on the retention ballot, but lawyers don't want you going out raising money and campaigning. And we didn't want to anyway. So against that backdrop, as we came into the summer and it became more obvious that there was going to be a campaign against us, the three of us talked about it, and we just didn't have a stomach for campaigning and raising money, and we thought it would really compromise us in the future, because then are we going to recuse ourselves on every case, or a lawyer who contributed to our campaign was on an appeal. We thought it would interfere with the court's work by us having to do that. We also felt that we didn't want to act like politicians. We'd been accused as acting like politicians in our vote, which I will say for the record was anything but a political decision. And we didn't want to confuse our role by campaigning like politicians do. And we really sat down and had a heart-to-heart with each other and said, listen, if we lose our jobs, we lose our jobs, but that is not as important as preserving the integrity of the court. I mean, it sounds, oh, you're so noble, you know, you're so wonderful. But I mean, it really did have to come down to that, and that's how all three of us felt, and we didn't have any reservations about it then or now.
So in retrospect, you wouldn't have done anything differently?
No, absolutely not.
Well, then let's talk about, you know, losing your seat in the election. Then suddenly you guys were unseated in November of 2010 and starting, I guess, with January 1st. But you gained widespread respect from at the same time.
Yeah.
And so tell us about what flowed after that. And in particular, I want you to talk about your receiving the JFK Profiles in Courage Award. Oh my gosh, please tell your story about hearing from Carolyn Kennedy's.
Well, it was really, it was so unexpected. I had a call from the Kennedy Library, which administers the award, but I didn't know that. That was not on my radar
It's
screen.
like getting a Phi Beta Kappa, you know.
But you know, this was like in the spring of, this was like a year later,
Okay.
like in the spring or the winter, like in January of 2012 or something. So we'd been off the court for a year, and so we had done, all three of us had done public speaking nationally. So I get a call, and Mike and Dave did too, from the library saying, we're thinking of having an event on judicial independence, and we just wanted to talk to you about, you know, who we might have and how it might be organized and what we might cover and that kind of thing. And I thought, well, that makes sense. Could somebody call you on Monday at 9 o'clock? And that didn't even sound odd. So I said, sure. And somehow Mike and Dave and I were all, did you get a call from the Kennedy Library? Blah, 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 blah. Yeah, we all had. And so we were all going to be talking to them like a half an hour apart. And I was the first one, and the call comes, and this person on the line says, this is Caroline Kennedy. And I'm thinking, oh my God, is somebody mean enough to set me up like this? And they're gonna have me act like, oh, Caroline Kennedy, and then find out later that I've been, what did they call that?
It's come up recently.
Catfishing
Yeah.
or something? I didn't know that name back then. And so I thought, well, wow, but is this real? And so I was very reserved, you know, and she told me that we were gonna get a Profile in Courage Award. And you know, so I thanked her and everything, but at the same time I was thinking, don't get too worked up about this, because this is probably a phony call. Isn't that awful?
It wasn't phony.
Anyway, but I was obviously very nice and very grateful to her and all that, and she was so sweet and wonderful. So then I thought, okay, I'm going to have to call the other guys and see what they think, but I had to wait for their phone calls to be done. So then at the end we all got together, you know, we all were talking to each other. Do you think this is for real, you know? And nobody would go to such an elect, and it sounded like Caroline Kennedy, you know, but we're still all, like, we can't believe it.
Yeah.
We cannot believe that they would give us that award. It was just, I think it was something that touched me and made me feel so good in the midst of such a horrible experience. I can't tell you how wonderful it was to have received that recognition. And it was so unexpected, and like, you know, geez, we were just doing our job and we get this award for it, you know, how lucky can you be? So it was really a marvelous thing.
You know, our friend, U.S. Magistrate Celeste Bremer, was, I think, at the Kennedy Library or wherever they have the plaque. I'm not sure where the plaque is. And she took a picture of it to send it to me. And it was touching to me just to see the names of some of my former colleagues getting that award among it. I mean, it isn't like they give that award every year, you know. It's like a real rare sort of thing. And you know, I think John McCain might have been in there.
I don't remember who, but yeah, I mean, we were in
really
such
remarkable
amazing
company.
It's just still hard to believe.
Well, let me offer my congratulations to you if I haven't already in the past.
I'm sure
I
you
think
have.
it's really great. Well, let's talk about, well, are there any other happy or disappointing memories about being on the Supreme Court that you wanted to share? And then we'll talk a little bit about your post-court life and wrap this up.
Well, you know, I just loved the people that I worked with. They were all such wonderful human beings. And it was really interesting those last few years because I felt that we were just working so well together. It was such a wonderful work experience. I mean, it always was, but especially those last few years seemed to really be special.
Well, tell us a little bit about your post-Iowa Supreme Court life and work. You've had 8 years now to kind of return to either the private practice or lots of other, I know some of the things that you've done, but share some of the highlights for us from the last 8 years.
Well, it was one of those things that people, like my mom would say, was a blessing in disguise. Losing my seat on the court, because they've just been a marvelous 8 years. I finally have time to relax and have quality family time. I did a lot of public speaking for the first probably 6 years. I now have a rule that I don't do any because I'm just sick of hearing myself talk.
And that topic would largely be the independence of the judiciary.
Right, yeah. And that was a lot of fun. I met a lot of people and I traveled all over, and I even spoke at the International Association of Lawyers, or whatever that organization's called, in Dublin, Ireland.
Yeah.
You know, so opportunities I never would have had. And that was fun, you know, for the time that I did it. I practice part-time, and the beauty of that is I do it out of my home, and I only take the work I want to do, and I do it when I want to do it.
Yeah. What kind of work? What kind of work?
I do consulting on appeals or at the trial court level, and generally when somebody contacts me, it's because they have something that they're not familiar with, or it's kind of a new issue, cutting edge, or development of the law, and they just want my input on it. And sometimes they have me write it. Then I do Title IX arbitrations for schools, and those are violations of not schools, colleges and universities who have charged a student with an act of sexual misconduct. So I serve as an adjudicator for those situations. I've done some mediation, but I'm not doing mediations anymore. I'm not suited for that. I don't have the patience for it, and I don't enjoy them. And I'm thinking, why am I doing this? Yeah. I do like arbitration, which, you know, is private decision making, so I do some of that. I think that's pretty much it. But it keeps me busy enough.
So the three little kids, who were, well, the three who were your children on the court, how old are they now, and where are they?
Well, they're all in their 20s. I guess maybe Whitney's 30. Whitney is an immigration lawyer in Austin, Texas. She works for a nonprofit there. Rob farms. My husband has a farming background as well, and his family farms north of Des Moines, and Rob's taken over the family farming operation. And our youngest daughter is now a college graduate and deciding what to do with the rest of her life. Probably go back to school, either grad school or law school, we'll see. So yeah, they're all grown up.
Cool. During this time, are there any other awards that you've received, or honors besides the JFK Profiles in Courage Award that you'd like to share?
You and I were named inducted into the Iowa Women Hall of Fame.
And together, that was sort of interesting,
wasn't it?
wasn't it?
It was fun, yeah. Yeah, that was nice.
Yeah. Any others that or have you done any other sort of volunteer work in town, or any other leadership sort of stuff?
I'm on the board of Iowa Public Radio and on the board for the Harkin Institute.
I wanted to ask you
Drake.
about that. That was one of the things that you did. You actually kind of headed that up to begin with. You were the first director, weren't you?
I did. I was on the board of trustees for Drake University when the board approved having the Harkin Institute at Drake University. And the president of the university at the time, and Sally Peterson, who was also involved in establishing the institute, kind of prevailed upon me to be the first director, to kind of get it off and running, and said, oh, it'll only be part-time, and we really need somebody to do this. And so somehow I got myself talked into doing that, which actually I've met a lot of wonderful people through that work, and I didn't know the Harkins at all, and hoped that I would like them since I was going to be the director of this institute. They're wonderful people. I really do like them. And so I did work there for 2 or 3 years to get it started. Now they have a full-time director who can take it to the next stage.
That's great, but you're still on the board.
But I'm still on the board, yeah.
That's great.
But one thing that we haven't covered that I do hope has some lasting impact, and it was one of the reasons that I agreed to be the chief, and that is to improve the way courts and the executive branch handles cases that involve children. And that was something that I became sensitized to when Justice Lavarado, the chief, then sent me to a conference in Minneapolis on children involved in the court system, because we minimized them and the importance of their case and the impact of their involvement in the court system on their lives long term for so long. And I felt that I was fortunate enough to be in a role where I could be an advocate for these people who had no voice, these children who were being scarred for life in some situations by the delay in finding families for them or getting them back to their own family. If there's anything important I've ever done in my life, I think it was whatever improvements I could encourage people to make in the way we process those cases, so the quality of the decisions were better, and that importantly, that they were made faster than we had been making them. There was a point in time where if there was a glitch in the schedule because a judge became sick or we didn't have enough court reporters or whatever it was, that the medical malpractice case would go to trial. But the morning of cases considering cases of abuse and neglect would be delayed a month. Wow. And these poor kids are sitting in a foster home. So to change the priority of the court system, to me, was a really important thing.
And as far as you know, has that ethics sort of continued, that goal?
Well, I'm always afraid to ask because you don't want to find out that it hasn't occurred. But I think by and large, from what I understand, yes, they are continuing to adhere to giving those cases priority. And one judge, one case, which was another really important change that we instituted, where you had one judge who was familiar with the case, hearing every matter that came up in that case, made a big difference in processing cases more quickly because they already were up to speed when an issue came before them. Yeah. And there were other changes, but those two I think were the primary ones, and they were just so important.
I think setting that tone at the top that you did with that, and I recall that emphasis in your State of the Judiciary addresses and so forth, that was real important to you, and it does make a lot of sense. I think the Court of Appeals implemented some really good shortened timelines for termination of parental rights.
Right.
In order to get children to permanent families as quickly as possible.
And you were on the court when we really changed our appellate procedure.
Yeah.
Remember, we cut all those times down substantially, at least in half, if not even faster, so those would be processed more quickly. And that all came about, without my leadership. I mean, that was an impetus, I think, from the Court of Appeals that was very important.
But you really carried that forward, as I said, and setting that tone at the top is really critical, and I hope it has continued.
Yeah.
as we kind of wrap up here, I wanted to ask, what do you do for fun and relaxation these days? We heard you don't like to sweat, but what else?
Well, I tell you,
like to do?
As my sister says, who's a little bit, I'm the oldest, so she's younger, she says, she retired about a year ago, and she said her job, at least half of her job, is to just take care of herself so that she can live a long time in good condition. And I consider that part of my job too. So I'm really into, cooking my own meals and being very healthy and mindful in what I eat and getting exercise. I mean, I do know that I have to sweat a little bit to try to stay in shape, to stay active. Part of the reason I like to work is, to use my mind to have that intellectual challenge that I think is so important. So honestly, I try to do things that keep me healthy and energetic and in love with life. I love to do things with my children and, help them when I can. I'm busy. People who say, I don't want to retire, I wouldn't have anything to do, I'm thinking, what are you talking about? My days are so full, I don't know how I ever worked.
Yeah.
How I ever had a real job.
Exactly, I can relate to that one.
So yeah, I've just really enjoyed my life these last 8 years.
That's great to hear. That is really great to hear. And, one of the questions would be, how would you like to be remembered? But I think your reflection on making a difference for children who get caught up in the judicial system it sounds like that's what was really important to you. Anything
Honestly,
else?
Well, I don't care if anybody remembers me. I don't. I mean, I'm sure I'll be you'll go down in history as the first woman on the Supreme Court, and I'll go down as the first woman Chief Justice of the Supreme Court, and realistically, that's how it's going to end up.
Yeah.
So beyond that, once everybody alive now is dead, that's all that's left. And I'm okay with that. I don't really care.
Yeah, I can remember my colleagues when I decided to take early retirement. Well, you're going to be retired for a long time and blah, blah, blah. I thought, I'm good with this. I'd be happy to be a nobody, Well, then I do want to just have you touch briefly on the significant event this week, and that the third woman in the long history of the Iowa Supreme Court is finally going to be sworn in. Susie Christensen will have a swearing-in ceremony on Friday. And I just kind of wondered what your thoughts were on that, or what your hopes are for her and for the court with her on it.
Well, first of all, I hope that in future appointments that the commission or the governor doesn't assume, well, we have our woman on the court, so we don't have to worry about that. Because I think the court ought to reflect society, and I think there ought to be, 3 or 4 women on the court, at least. I think that kind of balance is long overdue. During my professional career, I was not, I'll have to say, was not a vocal advocate for women, because I grew up in an era where that could backfire on you. I don't know if you had that experience, but you just kind of kept your nose to the grindstone, and you did a good job, and you tried to outperform any man doing that job, and your effort and success would be recognized, and you would achieve something in the end. And the view was always that as more women did that, more women would occupy positions of power. It would just happen naturally. Well, you know what? I'm done waiting. That isn't happening. That has not happened. And it upsets me. It really upsets me. And I think women should be in positions of power. And they should hold those positions in an equal number to men. And there's no excuse for that not happening. So my hope is that there are other women appointed to the court in the near future as people retire. It's long overdue.
This makes me think that when it was announced that you were going to be appointed to the court, and that would have been 7 years after I'd been on the court, I don't think there was anybody in the world that was as happy about it as I was. And I hardly even knew you, except I knew you had this great reputation. Because it's hard to be the only. It's hard to be the first and the only. Now, Susie is going to be back kind of plowing that ground again, being the only woman on the court. I'm confident that she's got the abilities to do that, and the talent.
Yeah.
But
I'm sure she'll be fine.
Yeah.
And I didn't think it was Well, of course, when I came on, there was you, so I didn't have to deal with that, being the only woman.
And you and I didn't always see eye to eye on things. It's certainly not on
No.
adjudicative stuff necessarily, but I always thought there was a lot of respect for one another, and maybe we made space for the other one, in a sense, to be heard. You and I don't have a hard time being heard generally, but you know, sometimes I think
Well, it was nice to have somebody to commiserate with. I mean, these men didn't have a clue. I'm sorry, but they didn't. I mean, they had wives at home
yeah,
who were doing laundry
Yeah.
and picking up clothes from the cleaners and taking the kids to soccer practice.
Yeah.
They were clueless. They literally were. They did not know what it was like to be us
yeah.
working on the court.
Can I share a story about that you told me one time, and I hope I get it accurately, but we were getting ready for court week. It was like a Monday, and you said that on a Sunday afternoon, because you were here in town, and it was a beautiful day, and the kids were playing in the yard, and you had a lawn chair with a pile of briefs, and you just thought, this is idyllic, you know, I'm reading briefs, and here's my family. And one of the children came up and said to you, Mom,
Do you know why I hate your job?
yeah, because you do it all the time. And I know my kids felt the same way, because we never went anywhere on an airplane or in a car without briefs.
I know.
You know,
I know.
so
You just hope you didn't scar them for life.
I don't think we have. I think we've got pretty good kids. I mean, we have wonderful children,
Yeah,
don't you,
yeah,
when you
yes.
think about it?
Amazing, right?
Yeah. Is there anything else that we haven't talked about here today that you would like to share?
Can't think of anything.
It's really been my privilege over the years to have served with you and thought of you as a friend, and
Me too.
worked a little bit after our retirements on various things together and projects and stuff. It's been a great pleasure.
Thank you for interviewing me.
It was my pleasure.
All right, stay. You two stay there. We have a little tradition where all four of us take a little picture of everybody who participated in this. So come on around here a minute.
All right.
Both.
Well, it was kind of fun,
Yeah,
don't you think?
it's easy.
Yeah, it was easy.
Good heavens.
Good morning, ladies and gentlemen. I'm Tom McNaught, Executive Director of the John F. Kennedy Library Foundation, and on behalf of Caroline Kennedy and our entire Board of Directors, it is my great pleasure to welcome you to the 2012 John F. Kennedy Profile and Courage Award ceremony. Please join in welcoming to the stage the recipients of this year's Profile and Courage Award, Marsha Ternus, David Baker, Michael Streit, and Robert Ford.
And my final task is to introduce the guiding light of the award committee and of this institution. What can I say about Caroline Kennedy? What I can say is that those people who say when they get a call from Caroline Kennedy that they say, Caroline Kennedy's calling? My God, this is just awesome. And they get a little bit scared. She is every bit as awesome as her reputation. She's also a lot more fun. She is a delight. She is the guiding light here. She is the one that makes this such a special, special place. So it's with my great honor to introduce our leader, Caroline Kennedy.
Thank you, Al. Thank you for not discussing baseball. Thank you. Good morning, everyone. This is a special day for the Kennedy Library, and I want to thank all of you for coming to share it with us, especially half the state of Iowa. It's wonderful to have all of you here to support our honorees and honor the memory of my father. All my life, people have told me that President Kennedy changed their lives. They decided to join the Peace Corps or run for office, volunteer in the inner city or outer space, because he asked them to serve our country and do what they could to make this a more just and peaceful world. The generation that he inspired changed this country, fighting for civil rights, women's rights, human rights, and disarmament. And they passed that inspiration down to their children and grandchildren. As the first truly modern president, he redefined America's timeless values for a global audience and recognized the power of each individual to make a difference. As we mark the 50th anniversary of his presidency, his time is becoming part of history rather than living memory, that his words, his example, and his spirit remain as vital as ever. At a time when young people often feel disconnected from politics, We need to reach across the generations and recommit ourselves and our country to these ideals. One way that we connect past and present is through the Profile and Courage Award. By honoring individuals who act on principle without regard for personal consequence, we honor the quality that my father most admired in public life. This is a special year for the Profile and Courage Award because we are fortunate to recognize 4 outstanding Americans who demonstrate how critically important it is that men and women of courage serve in all branches of government. The people we honor today say that they were surprised to learn that they had been chosen. They don't think they did anything special. They were just doing their job. But for public officials, just doing their job often demands a special kind of courage. Standing up for human rights requires courage. Serving the interest of all citizens, not just the majority, requires courage. As President Kennedy's ambassador to India, John Kenneth Galbraith, once observed, "It is far, far safer to be wrong with the majority than to be right alone." We owe a great debt to the 4 people we honor today for their courage and for the sacrifices that they and their families have made to secure a more just and peaceful future for all Americans. In 2009, in the landmark decision Varnum v. Bryan, the Iowa Supreme Court issued a unanimous decision holding that a statute limiting civil marriage to a union between a man and a woman violated the Equal Protection Clause of the Iowa State Constitution. Iowa Chief Justice Marsha Ternus and Justices David Baker and Michael Streit voted with their colleagues to make Iowa the 3rd state and the first Midwestern state to allow gay marriage. The eloquent opinion states in part, "Civil marriage must be judged under our constitutional standards of equal protection and not under religious doctrines or the religious views of individuals. This approach does not disrespect or denigrate the religious views of many Iowans who may strongly believe in marriage as a dual-gender union, but considers, as we must, only the constitutional rights of all people, as expressed by the promise of equal protection for all. We are not permitted to do less and would damage our Constitution immeasurably by trying to do more. In the final analysis, we give respect to the views of all Iowans on the issue of same-sex marriage, religious or otherwise, by giving respect to our constitutional principles. These principles require that the state recognize both opposite-sex and same-sex civil marriage." The decision of the Iowa Supreme Court sparked a political backlash. Nationally financed opponents of same-sex marriage ran an expensive and divisive political campaign intended to intimidate judges and legislators who oppose their views both in Iowa and beyond. Under Iowa's system, highly qualified judges are appointed by the governor and then subject to a retention vote every 8 years. The retention vote system is intended to provide a way to remove jurists who are unfit to serve, and the campaigns leading up to them have been characterized by the prevailing view that it is inappropriate, if not unethical, for sitting judges to engage in political electioneering. In November 2010, despite their long and distinguished service to the state of Iowa, Marsha Ternus, David Baker, and Michael Streit were ousted. They were the only 3 Supreme Court justices to stand for retention that year, and they are the only 3 judges in Iowa history to have been ousted in a routine retention vote. The justices were aware that they might pay a price even before they handed down their opinion, but they did not waver. In their decision, they wrote, "A statute inconsistent with the Iowa Constitution must be declared void, even though it may be supported by strong and deep-seated traditional beliefs and popular opinion." In 1963, as civil rights demonstrations throughout the South met with increasingly violent opposition, President Kennedy said, "We are confronted primarily with a moral issue. It is as old as the scriptures and as clear as the American Constitution. The heart of the question is whether all Americans are to be afforded equal rights and equal opportunities, and whether we are going to treat our fellow Americans as we want to be treated." Just as judges stood firm for civil rights 50 years ago, Marsha Ternus, David Baker, and Michael Streit, their colleagues on the Iowa Supreme Court, and dozens of other public servants across the country have put their own careers on the line to uphold the rule of law and extend the fundamental promise of equal rights. This award is usually given to elected officials in the legislative branch of government, but in honoring these three principal jurists, we seek to remind all Americans of the importance of an independent judiciary and its role in safeguarding our most fundamental rights. We are fortunate to have with us today three other Iowa Supreme Court justices who voted with our honorees. Justices David Wiggins and Mark Hecht are here today, along with current Chief Justice Mark Cady, who wrote the landmark opinion. I would like to ask them to stand now and be recognized. It is now my great honor to ask former Chief Justice of the Iowa Supreme Court, Marsha Ternus, to come forward.
Thank you, Caroline. And a heartfelt thank you to the members of the Profile Encourage Award Committee. This award is very unexpected and one that I will cherish forever. My pleasure in receiving this award is magnified by the fact that so many of my family and friends have traveled to Boston to share this beautiful moment with me. Your presence here means so much to me. I want to thank you for the unwavering love and support you extended to me from the day we issued our decision in Varnum, through the dark days of the vindictive campaign against us, and in the 17 months since the voters of Iowa removed us from the Iowa Supreme Court for our decision in that case. Your love and friendship remind me every day that the most important things in life are not position or power. They are the people in one's life. And because of you, my life is filled with happiness. I mentioned that this honor was unexpected. It was unexpected because when we cast our votes in Varnum, we weren't thinking about being courageous. We knew that our decision would be unpopular with many people. And as David said, we even knew in the back of our minds that we could lose our jobs because of our votes in that case. But we took an oath of office in which we promised to uphold the Iowa Constitution without fear, favor, or hope of reward, and that is what we did. The 7 of us on the court had decided many years earlier that we would be a court with integrity, that we would decide cases fairly and impartially, and that our only allegiance was a commitment to the rule of law. Those principles made our decision in Varnum clear. Our founding fathers wisely created a government based on the rule of law, but the rule of law cannot exist without judicial independence. And when I speak of judicial independence in this context, I'm referring to a judiciary that makes decisions based on the fair and uniform application of law, independent of, free of, outside influence. I recently heard Justice Anthony Kennedy explain the concept of judicial independence, and he said judicial independence does not give judges the freedom to rule as they wish. It gives them the freedom to rule as they must. Judicial independence is certainly tested when a judge knows his or her decision is contrary to popular opinion and perhaps will lead to the voters holding the judge accountable in the next election for ignoring the voters' views. Nonetheless, judges cannot base their decisions on public opinion polls, on the wishes of past or potential campaign contributors, or on the judge's personal beliefs. Because when judges begin to do that, we cease to be a government based on law. But the preservation of our system of fair and impartial justice is not solely the responsibility of judges. It is the responsibility of all citizens. There are forces in this country that seek to politicize the judiciary, so judges will be selected not on the basis of their neutrality and good character, but on the basis of their commitment to a particular ideology or to a certain view on specific issues. We must individually and collectively resist those efforts, whether they take the form of corporate campaign contributions or threats by groups with political or social agendas. Citizens must demand that judges be chosen and retained for their professional competency, for their ability to be fair and impartial, and for their commitment to look at the facts and issues of each case and only then make up their mind on the outcome. An even more disturbing trend is the demonizing of judges and the increasing intimidation of the judiciary, both of which we experienced in Iowa. Public officials and other leaders resort to name-calling and denigration rather than engaging in a civil discussion of the issues and constructive solutions. Calling judges activists or elitists adds nothing substantive to the public debate about the important concerns of our time. Instead, that type of bullying behavior weakens the ability of the courts to uphold the rule of law, to protect the social, political, economic, and civil rights of all citizens, not just those of the most vociferous, the most powerful, the most popular, or the most organized. At the end of the day, the debate about controversial court decisions and the judges who make them boils down to a simple question. What kind of court system do Americans want? A court system that issues rulings based on public opinion polls, campaign contributions, and political intimidation? Or a court system that issues impartial rulings based on the rule of law? If we as Americans value the rule of law, we must act as if we do. Efforts to intimidate the judiciary and to turn judges into politicians or theologians in robes undermine fair and impartial justice and will, over time, destroy the ability and willingness of judges to do their duty as faithful guardians of the Constitution. Only through an unwavering commitment to an independent judiciary can we assure future generations that they too will enjoy a society safeguarded by courts that uphold everyone's rights, liberties, and freedoms, a society governed by the rule of law. I'd like to thank the committee and Caroline for giving this issue the opportunity to be heard, and I'm terribly honored to receive this award. Thank you very much.
This is Dick Lyford. We're here today with Roger Stone. Roger's a member of a Cedar Rapids law firm, Simmons, Perrine, Moyer, Bergman. Roger has handled many large cases in his time, and one of them was the litigation the state of Iowa got into with the tobacco companies. The cases were settled for $2.2 billion, and part of that settlement required the state of Iowa to pass some legislation and enforce it so that it could collect some money from the foreign tobacco companies and the small tobacco companies that did not participate in the arbitration. If it failed to do so, the large settling companies could then ask for a refund and from Iowa in arbitration in New York City. Roger, can you tell us about some of the legal issues that came up in the proceedings and how it was that former Chief Justice Marsha Ternus became involved?
Sure, I'll be happy to do that. The background for the matter really starts with the tobacco companies seeking to get Iowa's annual payment back on a claim that the state of Iowa had not diligently enforced the statute, as you mentioned. Iowa received about $55 million per year, and they were challenging Iowa's enforcement of that statute. As we got near the hearing that was going to be held in Chicago between tobacco and the state of Iowa, we received a report, an expert witness report from the tobacco companies written by a law professor from Columbia University in New York, and he had offered some opinions on 3 issues of Iowa law where he said Iowa didn't diligently enforce the statute because it could have done things differently than we had done them in our enforcement. That, of course, would have been inappropriate testimony. You don't need testimony about the law to a panel of arbitrators, and particularly this panel consisted of 3 former federal judges, Article III judges, who were more than capable of determining what the law should be in any particular state. We talked about moving to exclude his testimony or to file a motion in limine to bar his testimony. But we knew that that option would give the tobacco companies the chance to argue his opinions in writing, at least once, probably twice, and then they'd also get a hearing on their defense of their legal opinions of their law professor. And we were afraid by that time those opinions would be locked in concrete and somebody, the panel, might accept those opinions, and then we'd be in a worse spot than we already were. So instead of moving to exclude his testimony, we thought, well, we'll go out and get our own rebuttal expert. And of course, our attention soon turned to Marsha Ternus as a potential expert witness because she had just retired from the Iowa Supreme Court in 2 years previously after the 2010 election, and our hearing, as we were preparing, was in the year 2012. So we contacted Marsha and asked if she was interested, and she was, and we started in working with her on her background and preparing her report. She wrote a wonderful 31-page single-space typed report that was very comprehensive and just nailed the issues on our behalf. In fact, it was much, much stronger and a better opinion than the Columbia law professor's opinion. And when I happened to be in Boston in September attending the trial for the state of Maine, and the lawyer that was opposing Iowa was at that proceeding also, and he came up to me in the lunch line and kind of looked at me and said, 31 pages. How could you send us 31 pages? So anyway, she'd done a wonderful report, and then she came to Chicago during the Iowa hearing to testify in the proceeding. She was a rebuttal expert, and so you'd expect her to go late in the proceeding, but because she was scheduled to go to Dublin, Ireland to speak on another event, we asked if we could take her out of order and to accommodate her travel plans. And of course, they agreed, and the panel agreed she could testify early before their own expert, whose testimony she was going to rebut. And so I called her to the stand, and I just said, Iowa calls its next witness Marsha Ternus. Well, the panel chair was Fern Smith, a former Article III judge, a district court judge from San Francisco. And I think all 3 panel members knew of the Profiles in Courage Award and the circumstances of that award before Marsha Ternus testified. As I called her to the stand, Fern Smith, the chair, said, Mr. Stone did not address you by any title, and how would you like the panel to address you during your testimony? Do you want to be called Chief Justice, or how would you like to be addressed? And she said, well, my colleagues on the bench on the Iowa Supreme Court always called me Chief, and that would certainly be fine with me. And so she took the stand, and the direct testimony needed to go quickly because we were on a time clock. We only had 11 hours to present all of our witnesses and testimony and argument. And so we kind of quickly went through her direct testimony because the panel had the report that was 31 pages, of course. And then we turned her over for cross-examination. And we were hoping they would use up some of their time in cross-examination of Marsha. And she was marvelous on cross-examination. There were times when they would try to ask her questions to get her to agree with portions of Briffault's report, Professor Briffault's report. And she would look at the lawyer from Washington, D.C., Mr. Brookhiser, and say, Mr. Brookhiser, that's just not the way we do it in Iowa. And of course, she had written over 400 opinions of Iowa law during her time on the court, and she was such a scholar of the law. So we got done with her testimony, and then Mr. Briffault, Professor Briffault did come. It was kind of anticlimactic for him to get on the stand, and he didn't have an Iowa law license and hadn't really practiced in Iowa. But So we get to the closing argument and my opportunity to summarize the case and the testimony and what the panel had heard. And I was again short on time. I had no time left, and I actually had to go to the tobacco lawyers and beg for 24 minutes so I could do a closing. And they were gracious enough to give me the time to do a closing. I think they sized it up that if I didn't get it from them, I'd go to the panel, and the panel would give me time to do a closing. So they let me have 24 of their minutes. But anyway, I still had a few parts of the closing because of the time constraints. And so I got to the summary of Marsha's testimony, and I said to the panel, I said, we have these 3 discrete issues of Iowa law, and we've offered you the testimony of the former Chief Justice of the Iowa Supreme Court, Marsha Ternus, and I don't know what else I have to say. And the panel chair looked at me and said, Mr. Stone, you don't have to say anything else. So we knew we'd gotten a good result from Marsha. And then during the tobacco's closing argument, she interrupted the tobacco lawyer about halfway through and said to him, Mr. Brookhiser, we have these 3 discrete issues of Iowa law. And on the one hand, we've got the testimony of the former Chief Justice of the Iowa Supreme Court, Marsha Ternus. And on the other hand, we've got a Columbia law professor who doesn't even have an Iowa law license. So you could tell from her question and the way she phrased it that she wasn't impressed with Mr. Buffalt's report or his opinions about Iowa law. Yeah. And then when the panel did issue their ruling, and the panel did rule in favor of Iowa, and so we kept our $55 million. But they made a point of saying how good of a witness Marsha Ternus was and how she had clearly said what the law of Iowa was, and the state didn't have any choice except to follow the law of Iowa when it was diligently enforcing its statute. So,
wow.
Yeah.
Good for you. Thank you very much.
Well, thank you. It's a pleasure.